Ariana Ash present?
Yes, Your Honor.
Yes.
Yes. On the record, in the matter of the people of the state of Michigan versus Ariana Ash 24-03479, counsel appearance.
Good morning, Your Honor. Jason Markarian appearing on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Mr. Ash. We're both present via Zoom today.
So this was going to be treated as a probable cause conference because there was the need for conflict, counsel. Is that accurate?
Yes, Your Honor.
Okay. I see Mr. Yang filed his appearance of this matter. So we just need to schedule a date for an exam.
So I think probably wait the 21-day timeline to Your Honor.
Well, the court's gonna find good cause because there was a need for that conflict, counsel.
Yes, Your Honor, that's fine. I would agree with good cause.
And then there's a co-defendant.
There is, Your Honor. Mr. Stevens is actually on that file. We're in the hall real quick. I think it's going to be.
So there was no expectation to run them together.
We would, I think, want to run them together.
You say you would not?
We would, I believe.
Oh, okay. Let me see here. Okay, Ms. Ash, you have the right to have a preliminary examination within 21 days of the date that you were arraigned. However, because there is a conflict, or there was a conflict with you being represented by the Office of the Public Defender, conflict counsel needed to be appointed and additional time was needed for that purpose. So the court is going to find good cause to go beyond the 21 days to reset this. Okay, ma'am?
Okay, ma'am.
Okay. And Mr. Markarian, so that I'm clear, you're running or handling Ash, but Mr. Stevens would be handling Glasgow?
My understanding, yes, Your Honor.
Okay, he can come in, I guess. So I can
Turn it over at him.
set them at the same time. Is Mr. Glasgow here?
Yes, here.
Okay. Who says counsel?
Your Honor, I'm presently representing Mr. Glasgow. David Carter has accepted the appointment for conflict.
Okay, there was conflict for both, correct? Is that correct?
For Mr. Glasgow.
On the record, in the matter of the people of the state of Michigan versus Trinitarian Glasgow, 24-03480. Appearances for the record.
Andrew Stevens on behalf of the people.
And thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Glasgow, who stands present by right.
Okay, today was the date that was scheduled for his preliminary examination. I think last week, Judge Ward handled the probable cause conference. There was no conflict last week. Is something new to come up for him?
That is correct, Your Honor. There was not a known conflict at that time, so that has developed, or at least became known to the office subsequent to the probable cause conference.
Okay,
And so,
and is the conflict on both of his files for your office?
correct, Your Honor. Mr. David Carter has accepted the appointment as conflict counsel, and both of those, the schedule did not permit him to be here today, so I will remain as counsel for the purpose of this hearing, and would be making the request based upon that conflict for the court to find good cause and adjourn out both of Mr. Glasgow's preliminary examinations so that Mr. Carter can file his appearance, get the necessary discovery, and get up to speed on that. I made the people aware of that as soon as I was aware, although I think people's discovery of that conflict was nearly contemporaneous to our discovering that. And I also believe that people had a motion as it related to the co-defendants to, I think, consolidate the preliminary examinations for judicial economy. It's my understanding that people would not be opposing our request for a good cause.
Thank you, Judge. Judge, this is all regarding timing. Mr. Glasgow and Ms. Ash, who I know is present via Zoom, but unrepresented this time, were the first individuals charged as part of this overall investigation that happened on a weekend. Within 10 days of them, these two individuals, Mr. Glasgow and Ms. Ash, being charged, the people authorized additional charges against co-defendant Pharrell Morgan. Mr. Morgan is presently presently being represented by the public defender's office and was being represented by the public defender's office long before the charging of Mr. Glasgow and Ms. Ash, which is where the conflict that Mr. Austin is referencing. And so it would put Mr. Austin and his office in a conflict situation to then represent Mr. Glasgow. Just very, and from a factual standpoint, based on the investigation and some statements that have been made, specifically by co-defendant Pharrell, that in and of itself, some of those statements would also put a conflict situation or invokes a conflict situation for Mr. Austin and the public defender's office. So there's sort of the first issue, which is what Mr. Austin's talking about. The timing I bring up because, as Mr. Austin had referenced, we charged Mr. Glasgow and Ms. Ash first, but we then charged Mr. Morgan as a co-defendant. Although all of the charging documents identify all individuals as co-defendants, Mr. Morgan was arraigned and assigned to Judge Ward, not to Your Honor. And so the people intended on requesting today to have Mr. Glasgow's, even before we learned of the conflict, Mr. Glasgow's examination adjourned so it could be married up with co-defendant Morgan, because it is essentially all of the exact same witnesses for the preliminary examination. That would be consistent with Court Rule 6.110(a). I can give the court the dates of Mr. Morgan's current preliminary exam, probable cause conference and preliminary exam, but that's with Judge Ward, so they may not be of any consequence. So the people, in addition to not objecting to the request for an adjournment based on the conflict, are also requesting an adjournment of the dates so that this court can bring Mr. Morgan's case over, and all of these can be scheduled for a joint preliminary examination within the court schedule.
Mr. Morgan has not had a probable cause conference, or?
No, his is scheduled for the 20th, and then his examination date is scheduled for the 27th. But that, again, that's with Judge Ward.
Okay, I am positive I must be here, because I think she's out for the 20th. Let's see.
I can give you the docket. Anything regarding Mr. Morgan, I can probably provide you. I have JS up. I know you're.
That or you have it?
Yeah, I have it. What do you need?
No, just so that we can work out transferring it later. Do I need to give the case number?
24-03575.
Mr. Morgan's file number, so we can address that. I think I am having Judge Ward's PCCs next week. And Mr. Yang is now representing Ms. Ash, who's filed an appearance. And so we'll get Mr. Carter's appearance on this file. And same goes for you. I've already advised Ms. Ash, Mr. Glasgow, you have the right in this matter to have a preliminary examination within 21 days of today's date. But due to the fact that conflict counsel is necessary to represent you, and the time that it takes to appoint conflict counsel, and then as of today, the attorney that's going to take your case, David Carter, he has a conflict with today's date and even being here today. The court's going to find good cause to go beyond the 21 days so that we can reset this. Okay, sir? Do you have any questions about that? Okay, and so
And February 7th at 8:30.
or do you need another probable cause conference? Do we know if Mr. Carter will? I probably need to set it before that, because I don't want to wait till then and find out that Mr. Carter doesn't have what he needs. So I'm not here the 23rd, but the Or you said the 27th, it was the.
Correct. Currently, Mr. Morgan is scheduled for the 20th as a probable cause conference and his examination with Ward is on the 27th.
Okay, I'm gonna set these for a PCC next week. On the 20th. Just so I can address his file and see what's the best way to transfer. To the same exam date.
9 AM.
December 20th at 9 AM. And hopefully Mr. Carter will be available then.
And that's with you, Judge.
Correct,
Okay.
Judge Ward is out, so I think I'm handling the PCCs.
If I could make just one other note, and it may be irrelevant. If the examination for all defendants were to proceed theoretically on the 27th, I do know that I have at least 2 witnesses that are unavailable. I may be able to start the exam without them, and it would have to continue. Again, it could be irrelevant based on some of the mechanics that we have to work through, which we can certainly address at the 20th pre-exam conference. But I just want to make that sort of known because I do know that issue right now.
Sounds good. Any additional matters for you, Mr. Austin?
One additional clarifying matter, and I think the board had made inquiry of this at the beginning. I don't know that Mr. Glasgow necessarily has a conflict with the CCW file that I represent him on as well. I think primarily the A1 file, but both of those cases are being conflicted out to Mr. Carter. I think for nothing else, just for consistency and representation.
Okay, so. That's 24-03481. I can follow your reference. 80. Okay, well, no. 180, they wrote codependent on that one. Which one has the codependent? 8. The 80 is the conflict then. Is a codependent. Oh, so then I was right, the 81 is the one that doesn't necessarily have a conflict with a co-defendant, is what you're saying?
8-1, the assault murder. I would say this. I don't want to say that I disagree with Mr. Austin, but I'll just split the hair. All of Mr. Glasgow's cases, the CCW, because of the evidence that derived from that CCW case, which is 8-0 and 8-1, are all incorporated in this overall case presentation and investigation.
Okay,
And so for continuity, I would say the PD's office should be conflicted out on both files. From a factual standpoint, the co-defendants weren't together on the 8-0 case, but the evidence that it was collected as part of that case will be impactful as it relates to Mr. Glasgow and the co-defendant, Mr. Morgan. So I think it is best to have him conflicted out. I'm sorry, the PD's office conflicted out on both of Mr. Glasgow's files.
Okay.
That is correct. There is some overlap there, Your Honor. And that is what the office has done. So Mr. Carter will be accepting the appointment on both of those files.
and the courts are found with cause to go beyond 21 days on both files, so that this matter can be that with, once we get an appearance, or I guess a substitution from Mr. Carter.
So I can properly inform and update Mr. Carter. The probable cause conference will be held on both of those files next week on the 20th, and it will be at that time that the discussion of the preliminary examination takes place.
That's correct. Mr. Yang, do you have any questions on behalf of your client?
I just want to confirm the dates. So our PCC is set for the 20th as well at 9 o'clock, and then the prelim for the 27th. Is there a time for that yet?
I'm not set a prelim for Miss Ash, just another probable cause conference.
Okay, then we'll determine the date of a prelim next week then.
That's correct.
Okay, just want to confirm that. We will see you next week in person.
No problem. And it's a PCC, you don't have to appear in person. You can appear via Zoom.
Via Zoom as well. Okay, thank you.
Any additional matters for the record?
Nothing for the people, Judge. Thank you.
I have nothing additional on behalf of Mr. Glasgow, Your Honor. Thank you.
Thank you. You're all
Nothing.
set.
Thank you.
Thank you.
Is Alyssa Hill? Oh, she's in custody there. On the record in the matter, the people of the state of Michigan versus Alyssa K. Hill, 24-03482, council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf.
So have an attorney at all?
No, Your Honor, when we were at the PCC last week, the ROA showed she had applied for court-appointed counsel. It didn't show a denial. It just, I think the application might not have been processed yet by the PD's office. I still haven't seen an appearance on the file, so as far as I know, she doesn't have counsel. But it was my understanding she did want to be represented by counsel at the PCC, as of the PCC last week.
Ms. Strauss and Ms. Schroeder, can one of you all tell me what's going on with her application? Thank you.
Double check the notes. I want to make sure. Okay. Okay. So it appears, Your Honor, Attorney Aaron Schroeder from the Public Defender Office, it appears that Kareem Johnson did accept the appointment on this file back on November 26th. I have no idea what this is according to the notes here that we have in our system, but I do not know where we are at with regard to him filing his appearance. But it appears he did accept it. It was sent out to conflict counsel on 26th and it was accepted on the 26th of November. I will put a note into our file that the court needs his appearance.
We need his appearance in the file. We need his appearance at the court as well.
Yes, Your Honor, understood.
Okay, sounds good. So unfortunately, Ms. Hill, your attorney is not either filed an appearance or appeared for either court dates. So we'll have to see what's going on there. There must have been some kind of miscommunication. So if this matter has got to be reset, I'll reset this for another probable cause conference on December 20th.
Okay.
Thank you. 10 a.m.
At 9 a.m. Thank you.
And I am reaching out to Chief Assistant Public Defender, Mr. Cornish, and I will have him touch base with Mr. Johnson. Thank you.
Thank you. Ms. Hill, do you have any questions for the court today?
No, ma'am.
Okay, the additional matters for the record, counsel.
Nothing to indicate.
You're all set for today, Ms. Hill.
But thank you.
You're welcome. Record in the matter of the people of the state of Michigan versus Harry Jackson. I don't see this as well. Oh, there it goes. Harry Jackson, file numbers 24-03478, 24-02765. Council appearances, please.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Wayne Silverman from the Office of Public Defender on behalf of Harry Jackson Jr., who is standing at council table to my right.
Okay, we have a preliminary examination scheduled today for Harry Jackson II, correct?
Yes.
Yes, Your Honor.
Proceeding on that one today.
Your Honor, he's going to unconditionally waive that and have that go into circuit court.
People would also unconditionally waive their right to a preliminary exam on the file number 2403487 F1.
What's the month and date of your birthday, sir?
27, 1977.
there's a concern in this file that his birthday in JIS is August 27th. That's the date was on, the incorrect date was on the MC 97 form. It's MC 97.
Personal identifying information. for the complaint. Birth, driver's license number. That's the fingerprint.
Oh, okay, that has the right. address.
Yeah. Usually closer to the final.
This is it. This is incorrect. So what's the best way to handle that?
Verbally updated on the record.
Sounds good. So as the MC 97 form has the incorrect birthday, we'll amend that to the corrected birthday that should reflect February 27th, 1977, correct? Okay, that will be correct. Okay, so the parties are unconditionally waiving exam on this.
Yes, Your Honor.
Was there an offer at all?
That was plead guilty to a count of attempt R and O on this file. We would get rid of the have or defense as well as recommend dismissing violation. My ex doesn't want to take that offer. So that offer.
I'm talking about the one that's scheduled for exam today.
I apologize, Your Honor. You're right. Yeah, you're right. It was attempt R and O, and then it would get rid of that. Yeah, it was not. at all.
Okay, sounds good. Here is, I do paperwork.
So if I might need a moment to start this line.
No problem.
If I may, Your Honor.
I was just wondering if we should just call the next case and give them more time.
That's what I was wondering, because if I may, Your Honor, I just looked up the PCC email again, so that's a mistake on my end. To be clear, the offer that was sent, the PCC email dated 12/4/24, is plead guilty to an amended count 1 of attempt resisting obstruction and the PA 53 violation.
Sounds good. We'll give them, we'll go off the record so you can counsel.
Yes, sir.
I don't see Ms. Schroeder anymore unless she's behind this computer.
Just go check on that.
No problem.
Thank you.
Here she is. She's
Sorry.
back.
No, that's fine. No, it's fine.
Actually, Judge was just looking for you.
Oh, okay. I need to plug my computer. I'm sorry. Oh, I'm going between here and Judge Flores.
I was just asking on Nathaniel, you were
Yep.
over there.
Because they were telling me they wanted me over there and then Judge took me off the bench, like. Good times, good times for everybody.
Yep.
One, it's just. I gotta run a test on it at some point. Well, it's allegedly. Allegedly, it's a setting fix. And allegedly it got done, so. Let's see. I don't know. Downstairs, okay, you know where that is? Yeah.
So go off the elevator and then make a left and it's right there.
Okay, thank you.
I think left, yeah, that's right.
That's correct.
I gotta think about that. Sometimes I get my left and right. moving. I learned it as a baseball player, so I was thinking. Life is baseball.
Mhm.
Classes.
Yeah, so.
Yeah. Yeah.
That's just.
Record in the matter of the people of the state of Michigan versus Paul Curtis Young. This is 24-03468. Council Parent.
Morning, Your Honor. Case Mark Herring appearing on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Young, who's not present, and I would like to make a record as to what's been going on.
Okay, where's your client?
Your Honor, my understanding from speaking with his family, who have been trying to get him in contact with me as well. He is in the Ionia area. He is supposed to be at a mental hospital. They indicated client was being monitored. He was being monitored by them when I've spoken to his sister, and that he would be calling me back. I have not heard back from him. She's indicated that he knew his court dates as well as they were going to try to make sure he got here. But he is severely mentally ill. He is not on his prescribed medications for schizophrenia. They're trying to get him involuntarily committed, is my understanding from his mother and his sister. And it was my intention today, or at the first opportunity, to refer him for a competency evaluation, which I did advise the court of last week that may be a possibility. And I did advise the prosecutor last night that I had no intention, if he did show today, of running a preliminary exam due to the fact that I have serious concerns about mental health based on both the discovery and his family's reports to me. So I am hopeful that he is in a mental hospital, but I have nothing to support that at this time, Your Honor.
I also have a memorandum from pretrial services indicating a failure to comply with the bond condition to report to pretrial services within 48 hours. And that was on November 22nd. And the attempts made by pretrial services on both December 4th and December 9th have been unsuccessful. So his bond will be revoked and he'll be remanded in custody. Any additional matters for today's record?
Thank the defense.
Okay, we're all set.
Thank you.
Are you on the matter?
I'm here on the city.
On the which one?
The city conviction case.
Set at 10 o'clock.
Yes.
Schroeder might be ready on Simmons. I did want to advise the court based on the emails yesterday with Michaelson CC'd and your staff. That one witness I talked about, Shannon Beasley, is here. She just switched over one of her oxygen tanks. She said she's got about 2 hours and 45 minutes until she is on serious medical decline.
I'm ready to run.
Ready to run.
I'm, whenever the court's ready, I'm ready.
That's on which matter?
Quandale McCullum. It's 2 PEs. I expect it to be 3 witnesses. Might be able to go one.
What are we doing with Simmons?
It's just going to be a veteran court referral, so that's why
Okay,
I just wanted to let you know what the time was, Judge.
okay, sounds good. On the record on the matter of the people of the state of Michigan versus Clarence Simmons, 24-0146. Clarence, please.
Good morning, Your Honor. Case Mark Herring, appearing on behalf of the people.
And Assistant Public Defender Aaron Schroeder appearing on behalf of Mr. Simmons, who is present and is currently standing to my right.
Okay, Mr. Simmons has a preliminary examination scheduled today for police officer assault resisting obstruction. My understanding is there's going to be a referral to Veterans Court.
Yes, Your Honor, we do have to go through the process, specifically me on my end. After speaking with Ms. Schroeder this morning, we decided we might want to do this referral. She spoke to the client, my understanding it does. Now the next step in the process is I'm gonna have to review his entire CCH, which does include some assaultive history, but might still not make him ineligible for Veterans Court. I just have to obtain police reports. It's gonna take a little bit of time. And then we've got to get the transcript to 14. But if you want to set this for a review date, maybe a month out, that should give you time to at least start the screening process.
And that is correct, Your Honor. Further review of the discovery as well as conversation with my client indicates that he is a veteran and as such would in theory, at least initially qualify. It looks like we just need to get with background on. Thank you.
Okay, Mr. Simmons, you have the right to have a preliminary examination within 21 days of the date that you are arraigned. But in order to participate in the Veterans specialty court, that you would need to waive the 21-day timeline to give them time to screen your eligibility. Is that something you want to do?
Yes.
Is like threatening you to waive that 21 days? Is anyone threatening you to waive the 21-day timeline? Okay, does anyone promise you anything if you waive the timeline?
No, ma'am.
Okay, we'll set it for review. 30 days.
January 16th at 8:30.
January 16th at 8:30 will be the date for the review. So we don't need to appear for that. You can let me know if we need to set it up further prior to that date, okay?
Yes.
So just so I'm clear, Your Honor, I just want to make sure, Mr. Simmons does not need to appear, but we need to at least be giving the court an update on what's going on.
Correct.
All right, thank you.
Any additional matters for the record today?
Nothing from the people.
Nothing from the defense, thank you.
You're all set.
As soon as you get that paperwork from the district. I don't, yeah, can I text this?
Okay, on the record in the matter of the people of the state of Michigan versus Quan Del McCullum. Brought up
He does, Your
He
Honor.
does, Your Honor.
-02346 FY council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. McCollum, Your Honor, who is here. He's being brought up from.
Okay, we have a preliminary examination. Two preliminary examinations. I think PA 53, we're running all of those today.
Yes, Your Honor, just regarding the PA 53, it's my understanding, it might just be on the docket again, just perhaps you want to give a sentence to it, as I
Probably.
see JIS for sure. He did plead guilty at the last hearing we had, to 2 violations on that PA 53 for no contact. Detective Kennedy also testified at that starting this exam, and we requested a continue.
Oh, sounds
That is accurate, Your Honor. I do want to place where Mr. McCollum gets up here before things was also conveyed to us yesterday, Your Honor. I do want to hear.
Okay, sounds good. Off the record until Mr. McCollum is brought up. I don't know why the witness needs to be in here right now, though. Is this a witness?
It is.
Yes.
You have multiple witnesses?
Yes, sir.
Okay. Where was she seated before now?
Just right outside.
It was not a private room for her?
No, I didn't think she was comfortable sitting, just
Okay.
based on
Okay,
experience.
is she your first witness?
She is, she will be.
I need the defendant up immediately, though.
Don't do that.
Ellie should be in here, so to take over.
Sounds
Your
good.
Your Honor, Mr. Smith, he is currently unrepresented. He has obtained counsel. That one could be a quick one to do if you wanted. I believe his counsel just stuck in another county in another court right now. I don't think we have appearance yet.
Thank you.
Do you need your headset? Oh, yeah.
Your Honor, do you need Ms. Beasley to step up as witness right now or?
No, if that's your first witness, that's fine.
Yeah.
How are you? Good, how are you? Pretty good. It's Friday. No, I'll be here this weekend.
Oh, fun.
On the record in the matter, the people of the state of Michigan versus Roman Smith, 24-03483. Counsel appearance.
Good morning, Your Honor. Case Mark Marion, appearing on behalf.
Okay, and Mr. Smith, you are without an attorney, correct?
Yes.
Okay, it looks like you were denied public defense counsel, but you request, or you hired a retained counsel now?
Yeah, but I haven't been able to actually meet with him yet.
Okay, how did you retain him?
Over the phone.
Did you pay any money? Okay, what attorney is it?
William Mondale.
Please spell his last name for me.
Anadeo.
Okay. So you have the right in this matter to have a preliminary examination within 21 days of the date that you were arraigned. And you were arraigned on this November 24th. So it was scheduled for exam today, but due to your attempt to obtain counsel to represent you, are you willing to go beyond the 21 days so that we can reset this matter? Is anybody threatening you to do that? Any promises if you change your date for a later date? Okay. I'll take a date.
We can do February 7th at 9.
February 7th at 9 a.m. Do you have any questions for the court today? We're gonna get you a copy of the notice to appear in just a moment. Any additional matters for the record, counsel?
Someone going to be at PCC again, Your Honor.
I think you actually put a PCC before then. That was the exam date. You think you'll retain him this week?
Yes.
Okay, so.
Sorry, I can do this gonna be January 31st. And we'll do that again on that one as well.
I want one quicker than that, so I can make sure he has
Oh,
a
okay.
counsel and that they have discovery.
January 3rd at 9.
January 3rd at 9 a.m. will be your new probable cause conference. That way we'll make sure you have an attorney by then, okay?
Thank you, Your Honor.
No problem. Any additional matters for the record, counsel?
Your Honor, thank you.
Bond in this matter, which was set at 2,000 personal recognizance, will continue. Let's see. You're all set for today. We'll get you your notice in a moment.
The date time for that PC again, Your Honor.
The exam is gonna be February 7th at 9, and the PCC is January 3rd at 9.
Thank you.
You're welcome. Mr. Feigelson here? Oh, there it is. Okay, on the record in the matter of Wandell McCullum, or the matters of Wandell McCullum, he's now in the courtroom. And I believe there was something you wanted to address.
Yes, Your Honor, Mr. Markarian did convey an offer to not only myself, but to Mr. McCollum yesterday. I'd like to have those contents of that offer placed in there.
Your Honor, as of yesterday, we had ongoing negotiations to try to avoid having to get a preliminary exam on this, to get a resolution on this case, and frankly, to avoid having Ms. Beasley drag herself down into the stages. What was offered yesterday was to plead guilty to 1 count of assault with intent to do great bodily harm, 1 count of aggravated domestic violence second offense, and a HAB second offense notice reduction on file number 2402346 FY. In exchange, we would dismiss the remaining 3 counts on that file. We would dismiss the home invasion first file as a whole, as well as not issue some charges that are currently in review with APA Adam Pfeiffer for intimidation, bribing, and interference. Mr. McCollum advised us as of last night at approximately 8 AM through Mr. Feigelson that he did not want to take that offer. He planned to run his exam. That offer has expired. The people will be intending to run the exam and requesting to run the exam today and seeking to add additional charges. Mr. McCollum was made aware of all of this morning. He still chose to run his exam, so there is no problem.
Your Honor, if I can inquire of Mr. McCollum.
Yes, you may.
Mr. McCollum, you heard the offer that was conveyed to you last night, is that correct? You understand that offer, is that correct? So what do you not understand about the offer?
That's what I told you last night, but you already said there's no offer on the table, so
Well, it expires at the time of the exam. You haven't started yet, correct?
Correct. If I can take,
I would say it expires today, Your Honor. There's been a lot of back and forth and a lot of adjournments on this spot.
Judge, I think his confusion, he had asked if they could take off the habitual second offender notice. I did ask Mr. Markarian that last night, and I believe Mr. Markarian declined to do that, Your Honor, is that correct?
Yes, that's correct. We are
So
not
what's the
reducing-
confusion?
that's not.
Repeat the offer.
The offer was to plead guilty to one count of assault with intent to do great bodily harm, specifically count one.
Okay,
Count 4 of aggravated domestic violence, second offense, and do that with a habitual second offense notice rather than the fourth that's currently charged. In exchange, we would dismiss the remaining 3 counts on that file, the home invasion file as a whole, and not issue a possible 10-year felony charge. It is an offer.
you don't view that as an offer, you said? No. You decline?
Yes.
You can call your witness.
Thank you, Your Honor.
Thank you.
Your Honor, I have just one preliminary matter. I have showed all of the exhibits I plan to admit today, with the exception of Officer Rincon's body worn camera, just because I haven't had time to show the full thing to Mr. Feigelson yet. It's my understanding as discovery of that. I don't know if we have a complete stipulation to the photographs, but I just wanted to state on the record, he has reviewed it, yes.
I have seen them, Your Honor. I guess when it comes up, I will step at.
People call Shanetta Beasley to the stand.
Raise your right hand for me. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. There's a microphone that's in front of you. Now, the purpose of that microphone is not to amplify your voice. That means that speaking into that doesn't make it. You can remove yourself from the courtroom, please. Remove yourself from the courtroom and then turn your phone off. Thank you. It does not make your voice louder for me. And so you're answering their questions, but I need to be able to hear it. And so you need to keep your voice as loud as possible. If you don't understand a question or if you need to be repeated, you can ask that. If there's an objection from either the attorneys, you'll stop speaking immediately. And that's because I have to make a ruling on that objection, and then I'll tell you if you're allowed to give us that response or not, okay? State your first and your last name and spell both.
Shanetta Beasley, ShannettaBeasley.
Thank you. You can proceed, counsel.
Thank you, Your Honor. Good morning, Ms. Beasley. Thank you for being here. You know, we've dragged you out here a few times. I'm gonna try to get through this as quick as I can because I know you have some medical concerns. For the record, could you tell us exactly how long you're able to be here, what your concerns are?
Concerns is running out of oxygen, possibly about 2.5 to 3 hours, the most I can be here.
Thank you. We should be able to get that done in this time. I'll get right to it. Start by identifying some people here, okay? Do you know someone by the name of Tamaris James?
Yes, that's my daughter.
It's your daughter.
Yes, ma'am. Yes, sir.
How old is Tamaris?
She's 35.
Is Tamaris with us here today?
No,
You know why? You don't know, that's okay. Has Tamaris been receiving medical treatment recently?
yes.
How long, when did it start? Explain that a little bit.
It started at, I say about the second week of August.
Objection, I don't know if there's any foundation to establish how she knows this. I think it's hearsay and she knows.
Might be foundation.
Okay, objection sustained.
So you said she has received some medical treatment, I believe, starting in about August.
Yes.
Let's just talk about how you know that. What caused Tamaris to seek medical treatment? Do you know?
She was stabbed.
Objection, I think it's hearsay unless it's gonna be offered to show why she needs medical attention, but I don't want it to be offered.
Treat on for the truthless matter asserted.
It's offered to show why she sought medical attention.
Objection overruled.
So why did she seek medical attention?
She was stabbed 5 times.
Let me ask you this, did you actually go to the hospital?
I did not, they had her sent home in a zip to me.
So have you seen Tamaris since that August date when she started seeking medical care?
Yes,
How does Tamaris physically appear now?
shattered, trauma,
So let's talk physically.
disfigured in her face, these spots, on her body. Not only was it stab wounds, she was burnt with cigarette butts in her face. She had a couple other marks from knife marks across her throat. Some from a razor blade going across her finger.
Do you know how long she was in the hospital for?
Say, through the early morning, through late that night when they finally got done processing her and let her go. I was shocked by the phone call from the hospital.
Fair to say she went to the hospital that night,
Yes, I was told she was.
that same night that this assault was alleged to have occurred. Do you know if she has any permanent medical injuries as a result of this assault?
She does.
What would those be?
Her eye.
What's wrong with her eye?
She was stabbed inside of her eye. The blade actually went down into her eye, went down, punctured her eye. To this day, she,
Objection, I'd like to know how she knows this. I think it comes from speculation that she's a doctor.
To inquire.
I can lay a little foundation. Have you spoken with Tamaris about her injuries? When she speaks to you about this, what's her emotional state?
don't want to look at herself, shaking, asking herself why.
Did you speak with her close in time to the actual date of the assault when she came back from the hospital?
Yes, I did. I opened the door and I happened to see it, and
Did she explain to you what her medical diagnosis was?
that she can lose her eye. Almost lost her life.
I think that's all the sufficient foundation I need. I don't know if Mr. Feigelson wants to re-raise his objection.
Yeah, I'm good for now, Your Honor.
Thank you. No, that was a lot for you, Ms. Beasley, so we're gonna walk back. You talked about August, what year was that? Do you recall?
2024.
No, we're gonna work backwards a little bit to May 24th of 2020. Do you remember that date?
Yes.
Why do you remember that date?
Had some damage done to my home,
By who?
Mr. McCullum.
See you pointing to someone in the courtroom with us here today. This person that you name identified as Mr. McCullum. Do you know his full name, first and last?
Rondell,
So Quandale McCullum.
Idris.
I don't need middle name, but thank
Okay,
you.
but McCullum. Yeah,
So Quandale McCullum.
yes,
This person you know as Quandale McCullum, are they here with us in court today?
yes.
Could you please point him out and identify him by article of clothing he's wearing?
The black jumpsuit, inmate suit.
Your Honor, please let the record reflect Ms. Beasley as identified the defendant.
No objection, Your Honor.
So noted.
One more question, just because I'm reminded. You were gesturing and pointing to a particular eye when you were talking about tomorrow's injuries. Which eye was injured?
It's the right eye.
So the right eye. Okay. All right. That's okay. Now, we're gonna go back to that date of May 24th, 2023, where you said your home was damaged by this man, Quandale McCullum. Do you know what's at the location of 1412 Georgetown Boulevard, apartment B?
That's where I live.
That's your apartment.
Yes,
Is that in the city of Lansing,
yes, sir.
Ingham County,
Yes, sir.
state of Michigan?
Yes, sir.
I'm gonna take you to about 5 a.m. that morning. What happened around 5 a.m. that day?
Woke up to shattered, just hear something break. Thought at the time it could have been something falling over in the room, and got up to find out what it was, you know, by going to the room door, asking what was that fell, and to hear it tussling. I was just,
Were you able to, let me just break that down. You said around 5 a.m. you heard this shattering. Were you able to find out what that shatter actually was?
that's my window, my bedroom window.
How do you know that?
Standing in the doorway, seeing the glass broke, just broken open, somebody's body hanging in and halfway out.
So you had you said somebody's body hanging
Well,
halfway in and out.
Mr. McCullum's body.
So Mr. McCullum was halfway in and out of your,
Yeah,
after you heard the shatter.
yeah.
How long after hearing this shatter noise did you see him halfway in and out of your window?
I was in the front room in a medical hospital bed because I had just came out of a coma. It was released home, and my daughter was in my guest room. So I just pushed my walker to the door. And as I opened, that's where the tug of war was.
So how long are we talking here?
Oh,
You live in a
not-
mansion?
About
Is it-
about 30 seconds, about 30, probably not even 30 seconds, probably about 15 seconds.
Okay.
As you can see, I move pretty fast with the walker.
So you went from the living room to that bedroom after about 30 seconds. That's about how long it took you?
I said about 15 or 30 seconds.
15. Okay. Now, I know you said that it was Mr. McCollum who was hanging halfway in the natural, but it was dark. So how do you know that it was Mr. McCollum?
Hard lights is flicked on, because that's what I flicked on, because the TVs was on. Once the door opened, that's the only thing you can see, you know, it wasn't just his face and body was being basically presented to me by the people that was grabbing on him, trying to finish pulling him in, because he was making his way in, so they figured they'll help pull him in. But then he started tugging back, and I was on the phone with the police.
Could you see his face?
Oh, yeah.
Did you recognize his face?
After not, basically, he grew a lot more hair now, but I knew it was him.
At the time, did you know
Yeah,
it was him?
I knew it was him. Yeah,
Have you seen his face before this?
yeah.
Once, twice, a lot of times. You mentioned a couple times this tussle and people pulling him in and out. Who was involved in this tussle?
My daughter and my son-in-law.
Why, if you know, and it's fair to say if you don't, but if you know, why were they pulling?
Because he had constantly broke the glass to where he was making entry, but he thought it was mine. I was looking at it as he thought it was just my daughter in the room until he noticed there was a guy in the room as well. So he was proceeded in coming into the window. So they was tugging him, you know, getting him on in, but he was pulling back. He was refusing, but he eventually, you know, got out the window.
Backed out.
He backed out.
Did they push him out? Do you know how he got out?
No, just figured, just let it go. The glass was starting to point, you know, really didn't want no one getting too cut up and stuff in the situation. But yeah, he was making his way all the way basically in the room.
Now, you mentioned something about your daughter there a second. Who was staying in that room that he broke into?
Actually, it's my guest room. She came here from Tennessee, her and her boyfriend.
So was your daughter in that room?
Yeah, she was in the room.
Had the defendant been in your house prior?
He was not, yeah, I'm gonna say yes, he has, but not with my knowledge. I was in the hospital.
Okay, so do you have any way of knowing if he knew where your daughter was staying?
I would say he would, if he's.
How do you know that?
Because when I came home from the hospital, he was in my house.
So you've seen him in your house before?
Yeah.
With your daughter?
Yeah.
You mentioned something about he was trying to get at your daughter, or get after your daughter. How do you know that?
What, through the window?
Yeah.
No, I'm basically what I'm saying, the way the window in my bed, the bed, I had my bedroom, both of my car, my room, is my house. He didn't see the other person because I was shocked that the other person was in there also. But actually, she was the one closer to the window, and that's where the reaching came, and she was hitting him with the stuff on the table, you know, trying to get him to let her go. He was basically pulling her towards the window as he was pulling himself out the window, as if he was trying to take her out the window with him. But then that's where the guy jumped in.
So I guess what I'm getting at here is do you have any way of knowing why he broke into your house? What his intent once he got inside? Did he say anything? Could you see anything?
No, he never opened his mouth. No, he never said anything. At the time, the window was broken and trying to get in and out, of which way he figured he could never get out, but no words were said. They were just yelling at him, you know, and I just kept asking who was it, you know, because the name Quandale wasn't ringing a bell, you know, he always went by Q, you know, so.
Fair to say that what you observed when he was hanging through that window was, as you described, fair to say that you observed him putting hands on your daughter?
Oh, he had my daughter. He was basically trying to pull her, but she was grabbing like cups and glasses and stuff, trying to get him to let her go. Because as he got strengthened, people are trying to pull out the window. He was pulling her with him. And she was hitting him. That's why everything was thrown all over the room, because she was just throwing stuff, trying to get him to let go. And then that's when my son-in-law came and proceeded to help.
Then things got broken up? Were police contacted about this?
Yeah. Yes.
Did you speak to police?
Yes.
Did Tamari speak to police?
Yes.
Were any photographs taken of the damage to your home by police?
Yes.
Would you recognize a photograph of that damaged window if I showed it to you here today?
Yes.
Your Honor, permission to, or approaching with what has been remarked as People's Exhibit #1. I believe we have a stipulation for the admission of this, so I would move to admit as People's Exhibit 1 at this time.
Defense will stipulate your Honor.
This is
People's Exhibit 1.
one is admitted by step, okay.
Ms. Beasley, look at People's Exhibit #1. Do you recognize that?
Yes.
What's in that photo?
My chess table, my TV, the trash can, the bed is over to the window, which you can't see. But my window is busted out. My deceased sister's nephew, taped on the TV.
Fair to say that's a photograph of the bedroom from the window perspective?
Yes.
From outside?
Yes.
Is that a fair and accurate depiction of what your guest bedroom looked like after the date of, or on the date of May 24th, 2023?
It is.
Thank you, Your Honor. I have no further questions for this witness at the time. Commissioner Brixton.
Yes, thank you.
Good morning, Ms. Beasley. I want to turn your attention back to, you said this occurred in May of this year, is that correct? Or May of
No,
last year?
May 23.
And you said you had just gotten out of the hospital, is that correct?
I had got out recently, the month before, April 27th.
And you said you were there for a coma, is that correct?
I wasn't in a coma, but I wasn't in there like, yeah, it was like oxygen to the brain. Yeah, my oxygen had turned off and, yeah.
Were you on any medicine that would influence your ability to remember anything? You said you were sleeping at that time, is that correct?
Yeah, the time of the night that it was, everybody should have been asleep.
Okay, so you were sleeping, you were in the living room or in your bedroom?
I was in my living room,
Okay.
but I was in the bed.
Okay. You're like in a bed in the living room because of the coma, is that like a hospital bed, is that correct?
Yes,
And then you said your daughter, Miss James, was sleeping in the bedroom, is that correct?
I have 2 bedrooms.
Yep. Who was in the other bedroom, if you know?
It's my bedroom, but I was not in it.
Okay. But she was in one bedroom.
She was in my guest bedroom.
And then you said she was in there with your son-in-law, is that correct?
I consider her my son-in-law.
Was that somebody connected to her or another one of your daughters?
I only have one daughter.
Okay, so
it's
it's
to
her. So one of her friends, is that correct?
Yeah,
Okay, a male friend, is that correct?
yes,
Do you know that person's name?
yes.
Okay, what is their name?
His name is Jamar Allen.
And you said you heard the window being broken. You said about 20 seconds to 15 seconds, then you go to the bedroom door, is that correct?
Yeah,
And you're able to see inside the door, is that correct?
the door is open. I'm standing in the hallway, and the door is right there, and the light switch is in the outside of the hallway, so all I had to do is flick the light on.
Okay, so you're able to see what happened, is that correct?
Yeah,
And how long did this whole situation last between the person coming into the house, your daughter, and Mr. Allen?
well, once I got on the phone, I was told to get the call going on with the police. I went the opposite way because I needed to get what I thought I needed to get together and talk to the police. I felt with the man being back there, and he eventually pulled on out that,
So how long did that encounter last? We're talking 30 seconds, a minute, 2 minutes, if you can remember. The tussle at the window.
the tussle at the window. I'll say about 30 seconds.
Okay.
Yeah, about 30 seconds to a minute, I want to say, because he was tussling with her and then the guy came
I got
around.
you.
So,
And then you said you called the police, is that correct?
yeah,
And law enforcement showed up that night, is that correct?
Yeah.
And you gave a statement to law enforcement that night, is that correct?
Yeah.
Okay. You said at that night, he tried to pull her through the window, but she kept fighting him back, is that correct?
correct.
And you said you didn't say anything, is that correct? You said you had been over to the house before, is that correct?
Yeah,
Okay. The last time before that night, you don't use that.
I couldn't tell you, no, I couldn't tell you that.
All right. How often is Mr. Allen at the house?
Mr. Allen and my daughter came here together from Tennessee.
Okay,
Yeah,
I got you.
they came here to take care of me being released from the hospital. That's why they were at my home.
Okay. Now, so your daughter lives in Tennessee or did
She
live-
was living in Tennessee.
And you said you have not seen her recently, is that today, is that correct? So you don't know her where her
No,
whereabouts are?
no.
All right, I have no further questions from this people.
No, Your Honor, the people have no further questions for this witness.
Lisa, you may be excused.
Oh, thank you.
Probably should have addressed this as a preliminary matter, but I guess at this point I wouldn't move for sequestration of witnesses.
You're calling another witness
I do have 2 other witnesses, Your Honor, but if you want
on this
to,
particular file?
on the home invasion file, no.
Okay,
But
I'm just-
this witness's testimony, I do think overlaps a little with the second file.
okay, I just was gonna start because I don't know.
That's fine, I'm stopping.
I didn't write the venue down. I don't know if you questioned her about venue.
I did ask Ingham County, Michigan. Yes, Your Honor.
I mean specific address.
Yes, Your Honor. It was 1412 Georgetown Boulevard, Apartment B, City of Lansing.
Mr. Rymes.
Yes, Your Honor, that, 2 things, that is correct. And I think with regard, I have no issue with that, but I think most of the remaining witnesses are law enforcement, Your Honor. Is that correct?
They are. So I don't know if you want to kind of stop for now and continue the rest of your docket and finish this. I think it's
Your voice dropped. You think it might be what?
the only one running. Sorry.
That's fine. We can go off the record.
Yes, Your Honor. Thank you.
He can. Yep. Confirm this over there. What are we doing with Rymes?
Need to press a hearing, Your Honor. She is ready to go out from downstairs and I can let Ms. Nichols know.
Give me a moment to check on it.
Can we radio for them to bring up Shakar Rymes? No, Rymes.
And just as an FYI to Your Honor, I know Mr. Rodriguez is here, that is ready to be sentenced. I know we are also ready on Carrie Jackson. But if you want to start with that city case, that'll give me a second to kind of talk to this, Your Honor.
And Your Honor, if I correctly am remembering the emails I received, I think there's a new violation to be arraigned on, and then the reason for arraigned on. I don't believe the recommendation has changed. And given I suspect it's going to be the same results regardless, and she's not contesting hearing, I don't know if the court wants to still arraign her on it or just proceed on the previous one she's been arraigned on. I received no new recommendation, and the one I was already received was a recommendation of already terminate and impose the jail sentence, so I don't imagine the recommendation will change.
Yeah, things can change. On the record in the matter of the people of the city of Lansing versus Shaquille Sheree Rymes, 21-01039, council appearance.
Staples for the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Ms. Rymes, who's standing to my right.
Okay, Ms. Rymes, today is the date that was scheduled for a probation violation hearing. We do have a new violation that I signed, looks like on the 10th. That you likely need to be arraigned on. However, as indicated by your counsel prior to going on the record, the recommendation from the probation department is not likely to change after or considering this arraignment. So I don't know if it's meaningful to move forward with that violation, but I'll leave. We'll see how this goes. We're not having a contested hearing.
That's correct, Your Honor, we are not.
So she's going to plead guilty to the violation.
That's correct, Your Honor. And those were the violations I received earlier, or I'm sorry, in late November, I believe, dated February 29th, 2024. And I believe there's two violations there, I'm sorry, it's just number 10.
Okay, I have violation number 10 that you failed to refrain from alcohol per Abraham on February 4th, 2024, positive for alcohol yielding a result of 1,564.88 nanogram per milliliter and 1,217.36 nanogram per ETF. That's accurate.
That's correct, Your Honor.
And you understand your right to have a contested hearing, ma'am?
Yes, ma'am.
You want to waive your hearing? You want to have the hearing today?
So the hearing is where the allegations are fine through. So if you want to run that hearing, you would say yes. If you don't want to run that hearing, you want to accept that you said correct, you would say no, not up to you.
You do not want to run the hearing, ma'am? Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, I'm threatening you to give up your hearing today and plead guilty to that violation. Is there any promises extended to you if you plead guilty? Add to the violations from February 29th, 2024. You tested positive or failed to refrain from alcohol. How do you plead? Actual basis, please.
Thank you, Your Honor. Ms. Rymes, is it true that on or about August 3rd of 2021, you were sentenced by Judge Simmons? Yes. And that was to a term of probation, correct? Yes. And during that sentencing, she went over with you a number of the conditions of your probation. Yes. One of those was to refrain from the use of alcohol, correct? Yes. And is it true that in February of this year, 2024, specifically on February 4th, that you did have a positive test at AberHealth for alcohol? Yes. And is that because you consumed alcohol? Yes. And you knew that was a violation of your probation? Yes. Thank you, and I believe that satisfies the factual basis.
Any questions from the city?
None from the city, Your Honor.
Court is satisfied with the factual basis on accept your plea, find your plea be free voluntarily and intelligently. The recommendation is to terminate the probation status and impose a term of jail time. Says here that the overall progress was poor and that the acceptance of responsibility was poor. Last report from MMRS was that the defendant had not attended services since March 15, 2024, and that the defendant had absconded from probation since March. You can address the court.
Thank you, Your Honor. That is the recommendation I received from the probation department in my discussion with Ms. Rymes as to what has been going on here with her on probation. She does fully admit to me that she is someone who struggled here quite a bit and does acknowledge that back in March, shortly after she became aware of the violations, she told me she just got scared. She assumed and figured that that positive alcohol test was gonna land her in jail, and so she made some poor decisions as a result of that anxiety and fear. That being to kind of fall out of the purview of the court and her probation officer. And since that time, she has not made contact with the court because, as she told me, she's afraid at this point, and perhaps not unfairly so. She did talk to me about other things that she has done in the meantime and some other things she has been struggling with, including a lupus diagnosis that has taken a downturn in this year and has caused some problems for her. She is proud of the fact she is working right now. She is working at the Rosewood Senior Foster Care Center, which has been for over a year full time. That's obviously work that's important to her. And she feels quite strongly about, not just for her own sake, but for the sake of the satisfaction of the work itself. She has enrolled in the CATS program at the Eagan County Jail, as she's kind of coming into the realization that she needs more help than she can provide herself, needs more help than probably probation can provide her at the time. So that is services that she's hopeful to continue taking advantage of for any time she's spending in custody. And she's already asked me about the possibility of my office providing help and resources for her and continuing that after any term of incarceration. To that end, I've involved our social worker, Beth Ingham, in services with Ms. Rymes. I understand what the recommendation is here, so does Ms. Rymes. It's not entirely unfair. I would ask the court to consider an order that was made in December of 2023 to prevent a prior probation violation. That time, the court held 30 days in advance upon the successful completion of probation. Obviously, there's not been successful completion of probation at this point. And I would ask the court to consider keeping its sentence at this stage to that prior order from December of last year, that being the 30 days that was previously ordered. Thank you.
That was for that violation. Just got another violation, now absconding, haven't even arraigned her on it. Does she want to say anything for herself?
Yes, I'll take full responsibility for what I've done, so just put it in God's hands, whatever happens, whatever you decide.
I can appreciate the statement, you want to put it in God's hands, but you didn't put it in God's hands, you took it into your own hands. You took some actions that you can't say you put in God's hands. You drove while under the influence of alcohol. You received a pretty nice plea deal, and you were granted an opportunity to do a term of probation. And I toiled with you for a long time, trying to bring you into compliance, an unreasonable amount of time, actually. Very few courts would have went back and forth with someone who has violated probation as many times as you have. You recognize that?
Yes.
You had, even before we had a formal violation hearing, you violated probation. And your probation officer at the time, Mr. Ledesma, gave you some grace. He let you waive the probation violation through him and adjusted your course of treatment, thinking it's early, maybe she can get on track. Shortly thereafter, I get a violation request, and there's 1, 2, 3, 4 violations that I have to address with you. We address it. A month later, you're back before me with 1, 2, 3 more violations. I extend your probation. I put you on scram tether. You're not compliant with the scram tether. And I put you in the scram tether because I couldn't get you to go test. And you then also were failing to participate in outpatient treatment. So anything that the court attempted to do to try to bring you into compliance and try to address the underlying issue, you were resistant to. You didn't put it in God's hands.
That's fine, yes.
If you had put it in God's hands, you would have been compliant. And so you are not going to be rewarded for the fact that you just are giving it up and now stating that you put it in God's hand. I promise you 30 days. And that was a sentence to a previous violation. That's not the sentence on the new violation. You're going to serve 30 days that I promise you, because that's what I promised. So you're going to serve that 30 days, and then I'm going to sentence you additional 30 days on this violation. So that's 60 days Ingham County Jail. No EER, no GPS tether release. He'll be discharged from probation. I don't see that she owes a balance.
That's correct, Your Honor. She's at zero balance at this time.
So nothing needs to be referred to, and I won't bother arraigning you on an abscond because it's not meaningful. Let's see.
And Your Honor, just for the record, just so I make note of it, I believe at this time she does have 16 days credit.
Excuse me?
Sorry.
No, ain't no excuse me. Don't use that language in my courtroom. He's struggling a lot. Do you have any questions for the court? Yeah. Any additional matters for the record?
I'm from the city, Your Honor.
Nothing further.
Thank you. You're all set.
Thank you, Your Honor.
Thank you.
Sorry.
Mr. Jackson. State of Michigan versus Gary Jackson, 24-03478. Is your phone off?
Yes.
And weren't you instructed to turn it off before?
Yes, ma'am.
And so you didn't do it, and then it rings again, and then you blurt out disgusting language in my courtroom?
Sorry.
Yeah, well, it's a fine of $100.
Yeah, for sure.
Yes.
Vice rights on the, on two cases. One is for the PA 53 and one is for the, if it had been set for recognition.
Thank you.
Yeah.
Okay, so there's two advices of rights, and Ms. Markarian, that appears to be drafting some
Please, yes, Your Honor.
plea sheets. Okay.
stating the agreement with the pleading, 353, and then they're using the RNO to intent on them to. I mean, unfortunately. Thank you.
Thank you. Okay, I do have a plea sheet for both the remaining files since defendants plead guilty to count one of attempt resisting obstructing in file number 24-03478 and plead to the PA 53 violation in 24-02765. That's completely inaccurate.
Yes, sir.
Yes, Your Honor.
The remaining was to be dismissed.
It's really an amended. count,
Amended after
Your
this.
Honor, yes, what goes away is the half for the offense notice because it's a misdemeanor.
Attempted, That's how you want to proceed, Mr. Jackson?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
It's true.
No, that's not what I asked you. I said, did you solemnly swear? Raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give is the truth and the whole truth
Yes.
under
ma'am.
penalty of perjury? Okay,
Yes.
thank you. Okay, so there's an advice of rights in each file with a plea information sheet. You've gone over this with your attorney, I'm sure, correct? That's your signature?
Yes.
You understand the rights here?
Yes.
You understand that you would be giving up all of these rights if you pled guilty to the amended count?
Yep.
Yes?
Yes.
Okay, so that means you're gonna give up your right to be presumed innocent until proven guilty. So you have the right to require the prosecution prove your guilt by proceeding to trial, and they would have to prove each element of the charge being brought against you beyond a reasonable doubt. Same goes for the PA 53 violation. You understand that?
Yes, Your Honor.
Okay, and you have the right at the time of trial to remain silent, not have silence be used against you. You have the right to see, hear, or question any other witnesses that they intend to call to testify against you. You have the right to have witnesses subpoenaed to testify for you, or you can waive your silence and testify on your behalf. Do you understand those rights that you've been
Yes,
given up? Has anybody made any promises to you to get you to give those rights up?
No. No, ma'am.
Has there been threats in order to get you to plead guilty today?
No.
Are you currently on probation or on parole?
No, Your Honor.
You understand that by pleading guilty, it could have impact on where you can travel or get immigration status.
I'm aware.
You also could have to report this conviction to your current or future employer.
Yes.
As to the amended count in file number 24-03478, attempted resist and obstruct an officer, how do you plead?
Guilty.
And we recognize that has a penalty of 1 year and or $1,000 fines.
Yes, Your Honor.
And are you pleading guilty to that because you believe you're guilty?
Yes.
As to the bond violation in 24-02765, scheduled for hearing today. Let's see if we can find it. Which was bond violation alleging that you, on or about November 23rd, 2024, at 00 hours, did allegedly use alcohol in violation of your bond and violated your bond conditions by not, or by having causing a third party to have contact directly or indirectly with a Angela Ralston. How do you plead?
Guilty.
as to both of those violations, or just one?
Yes, sir.
Okay, factual basis.
I'm gonna take you back to, the court mentioned to November 23rd of this year. Were you at 4405 South Park, Creek Boulevard?
Yes, I was.
Okay, that in the city of Lansing, state of Michigan?
Yes.
County of Dane. Okay. Were you in a vehicle at that time?
Yes, I was.
Okay. And prior to that time or at that time, had you been drinking alcohol?
No. Oh, yes, yes, yes.
Okay. And at that time, were you in fact a passenger in the vehicle that was being driven by Angela Ralston?
Yeah, she was drunk.
Angela Ralston is the protected person in this case, that case being 2765 FY, correct?
Correct.
And you knew that you were to have no contact with her.
Yes.
Also, on that occasion, did the officers then stop you and ascertain, now, this next solicitation is for the primary offense of resisting obstruction. The officers were able to ascertain that you were not supposed to have contact with Ms. Foster, correct?
Correct.
Okay, and so they asked your name, but you gave them a false name initially, correct?
Correct.
Okay, and they asked you to step out, one of the officers asked you to step out of the car, and you didn't immediately, did you?
No, I did. Nope.
Okay. And then when you did step out, one female officer, Sydney Farrager, attempted to handcuff you, correct?
Yes.
And you struggled.
Yes.
To the extent that several other officers who were present on scene then assisted her in making the arrest, is that correct?
Yep.
And you believe that that constituted obstructing this officer in her duties?
Yes.
Thank you, John. I have no further.
People are satisfied with the factual basis.
The court is satisfied with the factual basis on exception plea and find you freely, voluntarily, and intelligently given. Are you okay, sir?
Yes, I'm fine.
Okay, because your body language makes me feel like you might be under the influence or something.
I'm not under the influence, I'm just exhausted. I am tired. That's it.
Your officer, or your honor, excuse me. I have been able to see Mr. Jackson in numerous settings, several times when he was in jail. So he clearly wasn't under the influence. And I will report that he always is, as you see him today. In fact, when he originally entered the plea, so one of these cases that we're going to have a sentencing on here in a moment, he acted that same way before your honor, and you had basically the same inquiries. He is quirky, to say the least, and
It's a little bit more than quirky, he can barely.
Agitated, just
What are you agitated about?
the whole thing, you know?
You ain't the victim. What are you agitated about? We're all here because of your actions.
Yes, ma'am.
You're the last person in this room that gets to be agitated. Court will accept your plea and find your plea to make freely, voluntarily, and intelligently. I don't even know that it's meaningful to do another PSI. I don't know that much other than a new conviction has changed since the time that the PSI on the one that's scheduled for sentencing today was prepared. And that was prepared back on October 18, 2024, a couple months back. So I don't know that we could essentially move to immediate sentencing on these.
No objection to that.
I was going to suggest that.
You can make, oh, well, I have the pre-sentencing report. Did you get a copy of that?
We weren't sent one, both neither I nor Ms. McCarrion, but we were allowed to, your clerk sent us one, and I was able to go aside and slowly read through the entire report.
Do you have a copy?
Oh, just on my computer.
Okay, I just want to know, do we need to make corrections, updates, or deletions?
No, it appeared to be accurate, Your Honor.
Okay. Did you have a victim that wanted to make a statement today?
Your Honor, we do have Angela Ralston present. She advised me that she wanted to make a statement on the defendant's behalf at sentencing. That's all I know.
That she does want to make a
She
statement?
is here. She doesn't want to make a
She
statement.
can do so at this time. solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. Okay, state your first and last name and then spell both of them, ma'am.
Angela Ralston, ANGELA RALSTON.
Okay, what did you want to share with the court?
Me and Mr. Jackson have worked together for 20 years. Our relationship has not been the best. I won't let him take full accountability for things. We're here today because I had cheated on him and he reacted in a way he couldn't take it. It was not the first time, it was the second time. I have seen, since this last situation, I have seen Mr. Jackson take accountability and seek and do things that weren't ordered from you. Like, he has an anger issue. He went, found a therapist, been seeing the therapist, been going.
How do you know?
My daughter takes them, so she tells me this. Mr. Jackson, I just don't feel like throwing him in jail. That's what it is. He needs help, like rehab, like mentally. Because of what I've done, it has changed him. And I'd rather see him getting help than just thrown in jail.
Because of what you did, because of the cheating?
Yes.
Okay. And this is a situation where you find out you were cheating and he assaulted you. And you believe that because you were unfaithful, that warrants an assault?
No, I don't think it warrants, but due to it being the second one and the heated argument, things just got out of control.
Okay, did you put your hands on him
I did to defend myself back, yes.
after he put his hands on you?
Yeah.
Anything else you want to share?
No.
You're free to go. Thank you. You can make allocation.
Okay, I'll be brief. The agitated state that you see the agitated state is the only way I've ever seen him. I really can't argue against the jail recommendation. How can I do that with the record? I can't argue that it's not fair. I could argue, well, that maybe not the most effective. If you trimmed it a little bit and left probation time, that would allow some oversight. And you might think the question would be, but we've tried that before. If you look at his record, though, it appears that his prior offenses were not during a time that we had domestic relations court or domestic relations court type provisions. At least I don't believe so. And that would give some oversight. Why is oversight necessary? Because as Ms. Ralston just indicated, they've had a 20-year relationship. Every one of those prior records that required domestics involved Ms. Ralston. So despite what's happened with courts, for whatever reason, this couple stays together. And if he gets a straight jail sentence without any probation, if history, bears itself out, the history will be that once there is no hold over him, he's going to be back with Ms. Ralston. So it might even actually be more effective for Ms. Ralston to ameliorate slightly the jail sentence and have some probation. Ms. Ralston alluded to the fact that he's done something finally. I was given a document today by Mr. Jackson of counseling records that verify that he has he's had a session on October 7th, again on October 7th, on October 17th, on October 22nd, several sessions, and then again on November the 6th, and finally one on November the 20th, with a variety of counselors or clinicians as are listed here. So he has been doing something. Again, I'm not going to
But he
argue.
hasn't been there since October?
Pardon? The last session with Andrea Carlson, LMSW, was from November 20th. He actually has another scheduled, according to this form, scheduled appointment on the 18th, which I understand he probably unlikely to make, but he has been making these sessions, that it might actually be more beneficial for Mr. Jackson and certainly for Ms. Ralston if he does some sort of probation that has some intense, batters intervention, anything that the court could think of. Because the difference between, let's say, a 6-month sentence and a 1-year sentence with no probation is that he gets out, and again, history being what it is, he's back with Ms. Ralston, but the court has no holds on him, and he hasn't received, any kind of therapy or counseling or whatever. He's on SSI. I'm not sure. He says it's been since birth, so I suspect that the issues that he has that manifest himself today, the ones that he's always had. He's only had 8th grade education. He's got a whole bunch of medical issues. He's still ill from, if the court recalls, he was actually supposed to be here 8 days ago. He's still ill from that. So I'm just going to just throw that out there and leave it to the court's discretion as to what to do with Mr. Jackson. Thank you, Your Honor.
So Mr. Jackson has something he wants to say. Do you have something you want to say?
Yes, Your Honor. I'm also, like I said, I'm exhausted with me and her going back to back. And now that this time they'll be co-parent, I feel like I need to get back a little medication.
You need to do what?
Because it did mess me up.
You say you feel like you need what?
Get back a little medication. It's like I can't sleep. The way we used to talk to each other, you got to believe it to where that's what I was, So I went to go seek help, and it's working. Somebody to talk to instead of keeping it all inside. And I really don't want to go to jail. It's up to you, but I don't want to be the same person I was before I went in. So I ain't got too much to say. So
I don't know what you're.
I won't.
You don't want. There's something else you want to say?
Go ahead.
I don't know what your pre-existing medical and mental health it all entails. I know that when you present before the court, you present as someone who doesn't have a lot of control over themselves. That's how you present. Even as you're standing here, you have to have something in your hand. You're swinging stuff. You can't stand up straight. You're huffing, you're puffing. Your phone rings, you start cursing. I'm not looking for you to apologize. I'm looking for you to acknowledge that you don't seem to have control over yourself and over your body. This is consistent with your criminal history. Your attorney made a comment that I dispute, that every last one of these domestic violence on your record had to do with her. No, you had one from 1996. It's 30 years ago. And so so all of these are false. All of the domestics are false. You got one from 96, one from 2004, one from 2006, one from 2014, one from 2016, and one from 2018. But all of them are an aggravated assault 2016. He even had or been charged with felony aggravated stalking. But all of these, everything is fake. Yet you continue to present yourself in this courtroom as someone who lacks control. You're talking over me right now, which is someone who lacks control over their mouth. Your history here does not demonstrate someone who can do probation. That's what the report says, even from the pre-sentence report. You've been revoked or discharged or terminated from probation multiple times because you failed to comply. Even as this matter was pending, you were on bond. And we had to take a guilty plea today to a bond violation because of your failure to comply with the court orders, which is not just not to have alcohol, but not to have contact directly or indirectly with the protected party in this. I don't believe that the statement that was made that what's best for Ms. Ralston is for you to get some programming. No, what's best for Ms. Ralston is for her to leave you alone. If there's a 20-year documented history of violence between the two of you, then you all should not be together. And then your history extends beyond that, sir. You're not a candidate for probation. I'm not going to spend a 2025 going behind you trying to figure out why you can't comply. I'm not going to do that. It's not meaningful. What else are you doing with your life, with your days besides being at home?
Mr. Mom,
You said what?
I'm Mr. Mom, got all kids.
You have custody, you take care of the kids during the day? How many kids are there? What's their age?
14, 13, 20, and 21, and 2 grandkids.
Well, a 21-year-old's not a kid then, are they? They're an adult.
They're waiting for their mama to be adults.
So all these
All
children,
your boys too.
all boys live with you. What do you think you're teaching them? About how they should interact with their wives and the mother of their children? Your job is to be an example. Your job is not to refer to yourself as Mr. Mom. You're not a mom. You're supposed to be a dad.
Oh, okay. Yes, ma'am.
Excuse me?
Yes, ma'am. I didn't mean it. Yes. Okay.
I want to see the report from the.
It's not, it looks administrative document.
Is this the first time that you?
Yep, first time to find myself to do something for myself. Because I know I need help.
Okay, looks like 2 of these you were in custody.
Yeah, I was getting signed up for one of these cats.
How frequently are you engaging in the psychotherapy?
Until after I got sentenced today, it's gonna be once a week, but as of now, it's every 2 weeks. And I like her.
Only because you've taken your own initiative to get some psychotherapy. Am I going to give you one chance? And it's the chance is just so slim. I'm taking 0 violations, not a single one. Not a single violation will be tolerated, or you will be remanded to serve 180 days in jail. Do you understand that? Okay, so it's up to you, sir. I know you've not been successful in the past, but hopefully, at this point, you've taken some ownership over your need to get some assistance as it relates to what's going on with you mentally, and that will help you. That and the fact that you have to provide for children, you need to be there for them physically as their father, and you need to be an example. And that means showing them that you can have self-control even when you're upset. As a practice, it's a practice. You need to start practicing it. Start with keeping your mouth quiet while the judge is talking. That's the first place to start, okay? The other thing you should do is stop swearing in courtrooms. It's not necessary.
Just have it for me, you know?
Well, practice, it's a practice. I'm gonna put you on 12 months probation.
So I'm losing 5 points. Pay on time, pay before the due date.
Look, so I'm sorry? I didn't hear your question. Was there a question?
Never mind.
Don't interrupt the judge, please.
It was a practice, so he's getting, it's an early practice for him. And it's like you have energy that's trying to get out of your body, is what it looks like to me. So if that's the case, it's okay to clasp your hands and twiddle your thumbs, take deep breaths. Yeah, well, now's not a good time to start stretching and rocking because you are in a courtroom, but you need to start practicing releasing the energy in another way, okay?
Before I come in, yeah.
Yeah, well, while you're here too, because you can have nervous energy while you're standing in a courtroom or any setting, but you don't want to present yourself as someone who doesn't have control. So what you do is you find another way to release the energy so that you still present. You think he doesn't have energy he's releasing? I just saw him take a deep breath. He's releasing energy because you're stressing him out. You are stressing him out right now.
He answers what I call him.
That's what a good attorney does. Okay, 12 months probation. You're gonna continue the psychotherapy.
Yes, ma'am.
You're doing that, you said every other week?
Now it's about to be once a week, if she can get it. As of right now, it's 18.
Okay, I want it done one time per week. I think you need it one time per week. Let's see. Probably should put this on this. and that on that. Also, while on probation, you're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. And you'll provide evidence of that to your probation officer, okay?
Yes, ma'am.
Okay, you can't use alcohol as a coping mechanism at this time. You understand that?
Yes, ma'am.
So if you need to have some further treatment for that, we can get you enrolled in that. You understand? Because I'm not tolerating any violations. It's either gonna be a straight and narrow on probation, or you're going to do 180 days in jail, okay?
Yes, ma'am. Yes, you are. Did you take the, can I speak?
You have a question?
Yes, can I go home now
What do you mean?
to my address, 3220 Stabler Street?
You're asking me about a no contact order? Is that what you're asking me about?
I don't know what y'all got going on, but I ain't got no telling no more, so can I go home?
Home to where? Does she live there? Oh, I'm continuing a no contact order.
Are you serious?
As serious as a heart attack.
I live on the street. Oh, Lord. How are we gonna do that for?
The entirety of probation, or you can just opt for jail.
I was gonna
That's what you want.
ask
You go to jail, no, listen, you go to jail, I can't put a no contact order. That's your option. But you have a documented history of 20 years of domestic violence interactions with her. It's a no contact order that's gonna continue.
So.
Ask your question, sir.
Never mind. Never mind.
I'm gonna order him to participate in cognitive behavioral therapy. And intensive domestic abuse treatment as recommended by probation. Not to possess a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You will be required to submit to random preliminary breath testing and urinalysis testing, and you have to pay the fee for that, okay, sir? You can put your keys in your pocket. It's a $30 per month oversight fee that you're responsible for while on probation. So that's $360. That's a $75 crime victim rights fee plus $50 state minimum cost that you are also required to pay. Any questions about the fines and costs? I need another sheet of this. And that's it, and she'll check in with probation before you leave here today. So that they can get you set up to have this governor sentence drafted. I could have blank one of these, please.
I'll blame it after the sentence.
Yeah, because I just sentenced 10-124-03478. What's your phone number?
517-303-0462.
Great. Any additional matters for today's record?
None from the people, thank you.
None from the defendant. Thank you, Your Honor.
Actually, I do have one issue. The advice of rights as to probation, although you're being sentenced to probation, they're gonna run concurrently. You're on probation on both files. But the probation for the police officer attempted a resisting obstructing. You do have the right to request early discharge once you completed half the original term ordered by the court. But you'll still be on probation on the other file, okay? You have a question?
Pay all the fines, or I can get out there, right?
Pay all the fines and what?
Yeah, man. I'm scared to ask you a question.
Why? I didn't hear you because you're talking too fast. You said pay all the fines and then what?
If I pay all the fines, I can get off probation faster.
Well, no, what I was explaining to you is that one of these files is a domestic violence file, so you can't get off early. There's no option for early discharge. The other one is you're resisting obstructing. You could request early discharge. It's really not meaningful because you're still gonna be on probation, and I'm not ordering duplication of fines on both files.
Appreciate it.
And so you're only paying one oversight fee. You do still have a crime victim rights fee and state minimum cost on both files, but you're not gonna be paying oversight on both, and you can't be discharged on the domestic violence because it doesn't require early, or doesn't allow early discharge, okay? Do you have any questions? Okay, I want you to have a seat. We're gonna get you down to probation in just a moment.
Thank you, Your Honor.
You're welcome.
Thank you. That tissue. Sure. I don't want tissue. Wash your hand. This is mine. You got it.
Michael McCullum, and was there another one?
Anthony Rodriguez sentencing, Your Honor.
I don't see his attorney.
Right there.
Over here.
Oh, I can't
She's
see
hiding
behind the
behind the computer.
computer.
I had to plug in now.
Sounds good. the form?
Yes.
Where is it? Stick it in here. Here's the answer. I'm gonna fill it out before I keep and take this file down here. Okay, yeah, this is for this file.
Excuse me.
On the record in the matter of the people of the state of Michigan versus Anthony Alexander Rodriguez, 24-00035, counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Rodriguez, who is present and standing to my right.
The date that's set for sentencing, I do have a pre-sentence report prepared December 4th. Did you get a copy of this, counsel?
Yes, Your Honor.
Yes, sure.
Make corrections, updates, or deletions?
With regard to, I did review this with Mr. Rodriguez, and there is, I think the only update would be is that he did complete the 30th Circuit probation, is that correct?
Yeah.
Yes, he did successfully complete that earlier this month. That'd be the only correction, or not correction, but addition,
That he completed the
the felony probation.
entire probation, okay. I did see that it was noted that he had completed substance abuse treatment. Okay. Any other changes?
Moment.
Okay, you can make allocution.
Thank you, Your Honor. I, first and foremost, I'd ask the court to adopt the recommendations from this report. I do recognize that this started off as a felony, and I do recognize it is also, even though it has been pled to a misdemeanor, it is a one-year misdemeanor. It's still a assaultive type offense. However, the time period in which this incident occurred, and then the incident back that ended up with him in the circuit court, I guess for lack of a better way to put it, the summer of 2023 was not good for Mr. Rodriguez. And that does not excuse the behaviors he exhibited, but his relationship with alcohol, and I think he will also indicate that, was very bad. And it resulted in him ending up having to complete a term of felony probation, ended up with him being here on this matter and having to read reports that he did not remember entirely the things that happened because of his intoxication level, and having to be told by a nurse later at the hospital what had happened. He's been through substance treatment at this time. He has indicated to me that he has been abstaining entirely from alcohol. I do realize that there, as noted in the probation's report, there is a difference in the time period. I did discuss that with Mr. Rodriguez. The only thing he could think of is that he had written down the wrong year because of the fact that he was trying to think back and wrote down 2024, which is when he was filling out the assessment, as opposed to 2023. A lot of things were going on during that summer, and a lot of them unfortunately had to do with alcohol. And I think a lot of the time differences are unfortunately a lot attributable to that in terms of his memory of when he actually stopped. But he does know for a fact that after the incident that leads us here today, he has abstained completely from alcohol because he ended up in trouble very quickly in 2 different files, and as a result of his issues, and he just can't. He is here today with the support of his fiance. She was here earlier. I think she may have had to leave. Yeah, okay. But she was here earlier with him. I got a chance to meet with her. He has solid support, good employment. I'd ask the court to consider adopting the recommendation. He did complete the 30th Circuit probation successfully. He did not have any violations while in that programming. And I think in kind of a weird way, that probation addressed the issues because it's from the same time period, that same like May, June, July, August of 2023. I think it addressed in an odd way the same things that would have been addressed by a term of probation on this file. So I'd ask for that, the fines and costs to be adopted. Thank you.
Did your client want to make a statement?
Yeah, I just in 2023 I struggled really bad with alcohol. I was a daily drinker, and I got to the point where I was like blacking out, doing stuff that I don't remember. But since I've had a daughter, I'm with every day at work, Monday through Friday. My relationship with alcohol is non-existent. That's all I would say.
I see that the incident being August of 2023, there's been some time lapse, and obviously some changes in your life. Your criminal history didn't even predate that time period. So it's clear based on this information and the information that the court received from the questionnaire and your assessment that whatever was going on during that time was connected to the substance abuse disorder, which you've already successfully treated through a course of probation before the 30th Circuit Court. And so and you've completed probation without any violations, which is commendable. The court's going to adopt the recommendation. It's going to be a sentence of fines and costs. There is a $300 fine, a $75 crime victim rights fee, $50 state minimum cost that will be assessed. I believe that there was restitution. Correct?
No, Your Honor, if I may.
you may.
I did make contact with the victim on this matter yesterday to discuss the recommendations, if there was a restitution out or anything like that. I feel like I'm obligated, at least for the record, although you've already made your decision, I understand it, to point out that it seems to me, in reading the PSI, the recommendation for no fines and costs was largely based upon him being on a term of probation already, which is now ended. The victim on this matter was rather emotionally distraught, felt traumatized from this incident. She wanted me to take that note to the court. She also wanted me to request a term of probation rather than adopting the recommendations. I just wanted to put that on the record. But I understand you've already made your vote.
Correct. And the victim could have appeared today and given the impact statement if they wanted to.
I advised her of that.
She's not appeared. Again, the recommendation was, I can't interpret that the recommendation was not to put him on a term of probation because he was on a term of probation. I believe that the investigator would have known what his discharge date was. And so they also indicated in the report that the incident happened in May of 2023 and that he had been sober since 2023 and that he's already successfully completed substance abuse treatment, which was the root cause of the offense. And so I don't believe that the recommendation hinged solely upon the fact that he was presently at the time under probation. It's not meaningful to hold him on probation. He's not drinking, he had no violations, he's already done treatment. Probation is to be individually tailored and specific to address his assessed risks and needs. His assessed risks and needs have been addressed. So again, $300 fine, $75 crime victim right plus $50 state minimum cost for a total of $425. When will you make payments, sir?
I can start making payments today.
How much are you going to pay today?
I'll go pay 100. I just pay that here.
Yep, you'll go to the criminal traffic window. I'm just writing it up here. You're gonna pay 100 today and $100 per month until paid in full. Yep. Do you have any questions for the court at this time? Any additional matters for the record? Thank you, you're all set.
Thank you.
Okay. Back on the record in the matter of the people of the state of Michigan versus Juan Del McCullum. And this is in file numbers 24-02346 and 23-03167. We're ready to call your additional witnesses.
Yes, Your Honor. I do have an update just as a preliminary matter. I had not seen Officer Nicholas Rincon on this case up to this point today. However, I did have officers try to contact him, try to reach him. My understanding, he slept through his alarm, just woke up about 15 minutes ago, but is on the way, so I will present him second. I'm going to call Officer Mark Fox now, who is here present.
Sounds good.
And I believe we also have a stipulation to, well, in another preliminary matter to address, Your Honor. Although there are two separate files here, I did do my exhibit numbering in order from 1 through 7. I didn't do 1 for the home invasion case and then start over again and renumber at 1. Is that okay?
That's fine.
Okay.
No objection, Your Honor.
So then at this time, the
Okay.
people would move to admit pursuant to stipulation, people's exhibits number 2, 3, 4, 5, 6, and 7. I'll also have a clip of, or I'll have Officer Rincon's body worn camera as exhibit A, but we haven't reviewed that. We haven't stipulated to it yet, so.
Okay, sounds good.
But like, the only thing I question is depending on what it's gonna show, because if we already have enough evidence from this testimony, whether needed to present finding would be my question.
Might be true, Your Honor, but I'm seeking to add charges, so I would like to cover all my bases, and I think some of those additional charges are captured in the body worn camera of Officer.
Okay.
But if you could elicit some testimony.
Yeah, I can try through testimony
We'll
first.
see how
Sure.
it plays out. There won't be a stipulation as to that.
Sure, fair enough. Yeah, I wasn't trying to,
Okay.
there was no stipulation to number 8, that's Rincon's body cam. I was just referring to 2 through 7.
Sounds
I'd like to move to pursuant to stipulation.
No objection, first reading, Your Honor.
Thank you. People call Officer Mark Fox.
We have 5 weddings. They start at 2:30 though, so. 5 weddings. Oh, they love them. And I think we have 3 or 4 next week.
Wow, we need to get a reception hall in the lobby.
They want to get married, so that they can pay the taxes.
Not the taxes. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
If you can have a seat. Please state your first and last name and spell both.
Mark, M-A-R-C, Fox, F-O-X.
You can see counsel.
Thank you, Your Honor. Morning, Officer Fox.
Morning, sir.
Or afternoon, I guess, at this point. Thank you for being. Are you currently employed?
Yes, sir.
Where?
Lansing Police Department,
How long have you been employed with the Lansing Police Department?
18 months.
What is your current rank and assignment?
I'm a PO1 and I'm a patrol officer.
What do you do as a patrol officer in PO1?
PO1 is just a pay grade, and as a patrol officer, I take calls, I run traffic, whatever's needed on the road during the mission.
Have you, in your experience as an officer, responded to a call of domestic violence?
I have.
Have you responded to felony calls?
I have.
I'm going to move on and talk about the date of August 10th, 2024. Were you employed with the City of Lansing Police Department in that same rank and assignment on that day?
Yes, I was.
At some point, were you dispatched to a call at the location of 1904 Georgetown Boulevard?
I was.
Apartment 6?
Yes, sir.
Is that in the City of Lansing?
It is.
Hingham County?
Yes, sir.
State of Michigan?
Yes, sir.
Did you make contact with an accused at that location?
I did.
Who was that person?
The accused, Mr. McCullum.
Mr. McCullum, do you know his first and last name?
I don't recall his first name. I know his last name.
That person that you've name identified as Mr. McCullum, the one you had contact with, are they here in court with us today?
They are.
Could you please point him out and identify him by an article of clothing he's wearing?
A dark blue jumpsuit with a light colored undershirt, glasses.
Your Honor, please let the record reflect Officer Fox has identified the defendant.
No objection, Your Honor, by will cross.
Noted.
All right. Now that we've got kind of the preliminary stuff out of the way, let's dive a little deeper. What were you responding to this location for?
We got toned out for an active domestic in progress. And that's why I responded code to that location.
Now, when you responded to this location, where were you in the order of response? Were you the first responder? What were you?
I believe I was the fourth one. I believe there were 3 other officers on scene, or 2 other officers on scene. No, there were 2 officers on scene, Officer Racone and Officer Bynum were already on scene. And I was the 3rd or 4th officer who arrived. Officer Traverso and I arrived roughly at the same time.
So I'm looking at around 5:10 a.m. Would that be accurate or close to when you recall getting there?
Approximately.
So you arrive at about 5 a.m. You're not the first officer there. What do you do when you get on scene?
As I was pulling up on scene, I saw that Officer Bynum and Officer McCullum had entered into the residence, and I was still seated in my patrol vehicle. As I was getting out of my patrol vehicle, I heard a window break and the 2 officers come running back out of the house. And it was an individual who at the time I didn't know who they were. They turned out to be the accused, had jumped through the window and was running into the park north of the apartments. And I chased that individual on foot with the other 2 officers.
So yourself, Officer Rincon, and Officer Bynum, is that correct?
Correct.
When you arrive on scene for this call, what kind of clothing are you wearing?
I was in my full uniform.
What kind of vehicle you driving?
I was a fully marked patrol vehicle.
Would it be obvious, based on your experience, that someone that you are a police officer?
Yes.
At the time that you heard this glass shattering and saw this person run, let's start with Officer Rincon. Could you hear Officer Rincon ordering any commands to this person?
I could hear commands as they were running out of the house. And so along the south facing, where the doorway is the south facing, I could hear him yelling commands for police stop.
And specifically Officer Rincon, you're saying?
I heard Rincon yelling.
Objection, I think this is hearsay, Your Honor.
You want to respond to the objection?
Your Honor, I think it's going towards the next steps in this investigation, what Officer Marty Fox did after hearing these commands and seeing this person's voice.
Objections will be.
How do you know what Rincon sounds like? You work together?
Extensively.
Okay. So you're familiar with his voice?
Correct.
And this person you heard yelling these lawful commands, you identified as Officer Rincon.
Correct.
Let's talk about the continued pursuit out the back. Who, if anyone else, did you hear order lawful commands to stop?
As the subject started running, I started running, and when Officer Bynum was running north after the subject, I heard him also yell to stop.
After either of these officers commanded this person to stop, did he stop?
I do not believe so. I witnessed Officer Bynum tackle the subject to the ground.
Fair to say from what you observed, Officer Bynum tackling him is what got him to stop?
Correct.
Not by his own will?
Correct.
While this foot pursuit's going on, while the chase is going, well, let me ask you this. Did this at some point come to a close?
Did the foot pursuit?
Right.
Correct, it did.
What happened after that?
The subject was arrested, placed in handcuffs, and placed in the back of the patrol vehicle.
So after the subject's placed in the patrol vehicle, what do you do as an officer at this scene?
I went back with Officer Racone into the residence, and searched the residence for evidence of the crime. So I aided Officer Racone in searching the residence for evidence of the crime.
Did you speak to a person named Tamaris James?
I did. I spoke to the victim, Taurus James.
Now, before I get into what she actually said, I just want to lay a little foundation first, okay? When you were speaking to her, were you acting in your official capacity as a law enforcement officer?
I was acting in official capacity.
Was she aware that you were taking a statement that would be used in your report?
Yes.
Would the statements that you took from her narrate or describe the events of this incident?
Yes.
Were you able to confirm that a domestic relationship existed between the accused and Tamaris James?
I did.
Okay, now let's get into what she told you then.
From the beginning, sir?
Yep, I'll direct you, just 1 second. Let's start with the beginning. How did she appear? What did she look like when she was given the statement?
She was visibly shaking, crying, and covered in blood. She had a clear gash above her eyebrow that was bleeding down into her face and on the floor.
You recognize some photographs of Tamaris James if I showed them to you?
Yes, sir.
Did you take these photographs? I'll show them to you first. How about that? Approaching with people's exhibits numbers 3 and 4, Your Honor.
This is the victim, and this is exactly where she was seated when I was interviewing her. She's sitting on clear.
Do those fairly and accurately depict how Tamaris James appeared when she was giving this statement?
This is exactly what she was.
Approaching the bench, Your Honor. Let's talk about her statement a little bit now. Did she indicate to you how soon before you arrived, police arrived, this incident happened?
She stated the incident started approximately 10 to 15 minutes prior to police arrival. That's when it began, the fight.
Did she indicate when it ended?
She stated it indicated it ended right about the arrival of police.
So based on your conversation with her, were you able to come up with a timeline or an estimate of how long this altercation lasted?
Yes, between 10 to 15 minutes is how long the altercation lasted.
So we've got an altercation lasting about 10 to 15 minutes. What kind of altercation?
So she started with saying that they had an initial argument in front of the apartments where she stated that the accused jumped on her. She didn't elaborate on exactly what happened, and they came back into the residence, and the accused was having a verbal argument with not only her, but other people inside of the residence. In trying to calm him down, she said that she invited him to come lay down with her in bed, and they began to argue again. And the accused reached over and slapped her in the face. She stated that she slapped him back, and that a physical fight started that went from laying in the bed to standing inside of the bedroom. At that point, she said that the accused grabbed her by her throat, and she was very distinct in how she described it. It wasn't around the neck, but he grabbed her by the esophagus in the front of the neck and was punching her in the head. She said that she struggled for a bit to get his hand free, but eventually got his hand free from her neck. She stated the accused left the room and went to the kitchen and grabbed a knife. And when he came back, he was yelling at her and hitting her with the flat side of the knife, not the blade edge, the flat side, and stabbing her with the tip of the knife. She stated to me that when the accused heard the roommates, the other people inside the house, that they were calling the police, that he grabbed her again by the throat and slammed her onto the ground, and was hitting her in the face with a knife. She said at one point she felt that she was stabbed because she could feel the blood running down her face during this altercation. And the victim made a statement. She was very clear and concise when she said this to me, that while he was holding her down on the ground by her neck and hitting her with the knife, striking her with the knife, he said, "We might as well get this over with." She said she ended up pushing him. I think she used her legs to push him off of her. And right about that time is when police arrived on scene.
All right. You said a lot there, and I do appreciate it. I just want to break it down a little bit. Let's go back to, you mentioned that there was not just her, but other people involved. Do you know who those other people were?
I believe one of them may have been her mother, and then with total, there was, when I initially entered the residence, I believe there was 3 adult females in there. One of them may have been her mother, pretty positive it was, and I don't know the relationship to the other 2, but I know that they were present during the incident.
Let me ask you this way, were they just present during the incident, or did they get involved? They physically assaulted? Based on your investigation?
Based on my investigation, from what I know, I do not believe that those 3 females, those adult females that are separate from the victim, assaulted anybody. I know that they were involved in the verbal argument inside the apartment.
Now, you mentioned kind of a continued assault. Where did this assault start?
Well, initially she said that something physical happened outside, but it happened, the physical assault, the portion that she described happened in the bedroom, in a bed. That's where initially it started.
So let's focus on that. When you're describing, or when she was describing this situation to you, this assault on the bed, you mentioned at one point that she was grabbed by the esophagus. Did she describe any difficulty breathing or anything like that to you, loss of consciousness?
I don't recall her describing any difficulty of breathing.
Would it be fair to say she was a little shaken up at this point?
She was extremely shaken.
Was she giving you every key detail?
No.
Is that normal in an officer interaction like yours?
For her not to give every key detail, absolutely normal, especially since she was just assaulted.
Now, we've talked about this assault in a room. Did you at some point take photographs of said room?
I took photographs of the room.
Would you recognize those photographs that I showed them to you here today?
I would recognize them.
Approaching with People's Exhibits 5, 6, and 7, Your Honor.
So this is the west bedroom in the apartment at the end of the hall. This dresser is against the west wall, and this is blood that I observed on the dresser. This is blood that I observed on the ground, and there's other items on the ground that have some blood on them, the sandal. And this is a portable toilet used for someone who is maybe handicapped. I'd like to note that the room did smell like urine. I believe that this was probably full of urine and knocked over at some point. This is a leg for the brace on the side of the arm, and there was also blood on that. It looked fresh, so I photographed it.
So let me ask you this then. With these other people that were at the scene, these other witnesses, how were they emotionally at this point?
They were very worked up when we were there. When we initially arrived, they were very worked up about the assault that happened. They were kind of just telling us everything at once.
Did they appear to be under the stress of this situation while giving their statements still?
Yes.
How close in time to this assault did you take it, or were these people talking to you, giving statements to police?
So we had just arrested the accused, and based on the statement of the victim, that this was me talking to them was approximately within another 10, maybe 15 minutes after that, that I was interviewing the victim. So I would say within 10 minutes of the assault ending, I was inside the apartment and they were all kind of talking at once and telling us everything that happened.
So fair to say that they were giving these statements almost right after the assault happened?
Almost right after.
Do you recognize the name Janice McCullum?
I can't recall that right now.
You remember interacting with Latricia Miller?
Latricia Miller sounds familiar.
Do you recall talking with someone while you were at the scene, not the victim and not an older lady?
I spoke with a woman, I believe Latricia Miller, and they directed me to the knife on top of the sink, and she said that the accused had walked out there and thrown the knife.
Objection, this is hearsay, Your Honor.
Your Honor, I've laid the foundation for an excited utterance. I think it falls under that exception.
She stated that the accused had come out and tossed the knife at the sink, and that's where I found the weapon.
We have a photograph of the knife up there with us.
No, we don't.
Could you describe what that knife looked like?
So the knife was approximately, I want to say about a foot in length, with a silver blade and serrated edge on the cutting surface and a broken black handle.
Would you describe it as a kitchen knife or something else?
It's a kitchen knife. It's like a utility knife. It's in the kitchen.
How long again?
I would say it was about 12 inches.
Now, based on what some of these other people were telling you that were involved or at least witnessed this incident, why would you take a photo of a portable toilet?
So the portable toilet was in the room, and I believe that the mother of the victim lived in that house. She was handicapped. I know she had a walker with her and oxygen tanks, and I believe the mother was the one that utilized that toilet.
Now, are you sure she's her mother or just?
I'm not 100% positive that
some
she's her
elderly
mother,
woman
but
that
she's
was
an
there.
elderly woman that lives in the house.
So fair to say you were given some sort of information that led you to photograph this toilet
Yes,
as potentially being involved in the assault.
yes.
What do we see on that toilet?
I see fresh blood.
What about that dresser? Why'd you photograph that?
There was fresh blood on that dresser. Well, the assault had occurred in that bedroom. And so again, we're searching the bedroom for evidence of the assault. The victim had been stabbed. So I was in there looking for fresh blood, and I found blood consistent in all three areas with the fresh blood.
So in those three photos we're looking at there, people's exhibits number 5, 6, and 7. You photographed all of those because they had the appearance of fresh blood on them?
Correct.
Were those all in the same room?
Correct.
Did you notice any blood that was not contained in these photographs throughout the house?
I remember there being blood smeared on a wall. And I believe that there's was blood on bed sheets as well inside the house, but I don't have photographs of them, but I do recall there being blood smeared in other places.
Fair enough. Do you have any indication of how all this blood got throughout the house?
Well, I believe that that is probably from the victim. She was bleeding fairly good from that, I believe.
Now, at some point, you testified that somebody said something about calling 911, and then what happened?
So, the victim stated to me that when the accused had heard the roommates inside the house, the other people inside the house, that they're calling the police, that's when he grabbed her and slammed her on the ground.
Now, when you were describing her statement, you said hitting, you said striking, you said stabbing with a knife. Is that kind of your description, or can you explain that?
She said that he stabbed her with the tip of the knife, and I saw one wound on her thigh, and she said she had more on her torso, but he was also slapping her with the flat edge of the knife during the altercation as well. So he was slapping her, so hitting her with the knife, poking her with the knife, and then he struck her in the head with what appeared from the wound to be the blade edge of the knife in the cut.
Now, our court reporter doesn't get your hand gestures down,
Yeah.
so I just want to clarify. When you said stabbing, you were making a gesture with your hand kind of held at your side,
Yeah.
pointing forward.
That's how she described it, as a stabbing, and he stabbed her with the tip of the knife.
When you said hitting, you kind of turned your hand sideways and
So he was
swung
using
back and forth, almost like a slap.
Yeah, like a slapping. Like she described it as he hit her or slapped her with the flat edge, not the blade edge, but the flat edge of the knife. So either side of the knife. was slapping her. with that. So he had done 3 different things that she described.
And then at one point you said he had stabbed her with it. You kind of brought your hand down and like a tomahawk chop.
Yeah, and I believe that's when she described the top of her head. She was stabbing the top of her head.
So that's what the wound she was describing, the one on
Yes.
her eye?
Yes.
Do you recall which eye?
It was, as I'm looking at her, the right side of her face, and it was across her eyebrow.
So her right eye?
Yes.
Did you have any evidence to support throughout your investigation what the defendant's intent might have been during this assault? Did he make any statements?
She described to me that as he had her on the ground, holding her by her neck, and he said to her, "We might as well get this over with." And that was after the roommates said that they were going to call the police. He said, "We might as well get this over with." And she was very clear when she stated that to me. That's what he said.
Was this after the knife had been grabbed?
Yes.
Did he still have the knife in his hand while making the statement?
Yes.
So would it be fair to, so as she described it, he was on top of her with the knife in his hand and made the statement?
Correct.
She indicate to you how this assault stopped?
She said she had kicked him off of her, and the police had arrived at that point in time, and that's when the assault was basically done.
One moment, Your Honor. Thank you, Your Honor. I have no further questions for this witness.
Yes, Your Honor, thank you. Good afternoon, Officer Spence. Good afternoon, sir. So you said you were with Lansing Police Department for 18 months, is that correct?
Correct.
All right, and I assume you went to the police academy before that, is that correct?
Correct.
And you were trained to make an accurate police report at the academy, is that correct?
Correct.
And you did make a police report in this case, is that correct?
Correct.
And was it accurate and complete to the best of your knowledge?
It was accurate.
Let's talk about a few things. You said that on August 10th, you arrived 3rd or 4th simultaneously with Officer Traversy, is that correct? Correct. And you said when you were there, Officer Bynum and Officer Rincon were already present, is that correct?
Correct.
And how far away were you from the house?
15 yards, 10, 15 yards, something like that. I was in the drive. There's a yard between the house, and I was pulled up near the sidewalk, yard, residence.
Got it. Was it dark out there at that time?
It was dark.
Were there lights on?
There were lights in the front of the house on, and I believe there's street lights over there off of Georgetown.
And your lights to me are on the around as well.
My headlights were on
So you
there.
could see that far. Okay. And you said that you heard a window shattering, is that correct?
Correct.
And you saw somebody run, is that correct? Have you seen that person before?
No.
Can you describe what that person looked like?
At that point in time,
Yes.
when they were running,
Yes.
I couldn't tell you exactly what they looked like when they were running. After we grabbed them on the ground, I got a good look at them.
Did the person look tall? Did they look short? Did they heavy? If you could.
I would say 5'5", 5'6", 150, 160 pounds, something like that.
Okay.
When we grabbed them.
And you said you and the other 3 officers chased this individual, is that correct?
Correct.
And at some point, you guys were able to get them, put them in the custody, is that correct?
Correct.
And at that point, you were able to see who that person was, is that correct? And can you describe what that person?
At that point in time,
Yeah,
that night. Was a black male. I believe he was wearing darker colored clothing. And I walked by near the officers when we put them in the back of the vehicle. So I didn't get that good of a look at him, but
Maybe you've seen that person before.
prior to this date,
Prior to that.
I've never seen him.
Okay. And you said all you knew of that person was his last name was McCullum, is that correct?
Yeah, well, that's what I recall.
So no one said anything to you about his first name, is that correct?
I'm sure his first name was identified in the report, but at this point in time, I don't remember his first
So you learned his first name after the incident, is that
name.
correct?
After the incident, he was identified later.
And you know what time Officer Bynum and Rincon got there before you got
Oh, God, 2 minutes max.
there? Okay. And you said after you take the suspect into custody, go back into the home, and interview Miss James, is that correct?
Yes, I did.
Did you interview, you said you interviewed Miss Miller, is that correct?
I didn't interview them. They were just making statements at me. There was a lot of chaos inside the house.
Okay, I got you. So Officer Fox, so you said you made a police report in this case, and it was accurate, is that correct?
Yes, I added a supplement to the police report.
And in those reports, you've given a statement under the direct examination from Mr. Markarian about Miss Miller telling you where a knife was, is that correct?
Yes.
So is that in the police report that you submitted, or the supplemental report?
I didn't put that in the supplemental report. I photographed it twice.
And that was pretty important detail, you agree?
I would agree.
Why was it not in your report?
I don't recall.
Okay, and your duty is to make a complete report, is that correct?
That's correct.
And you spoke to the elderly woman that answered the door, is that correct?
The door was open when I entered the residence. Officers had already been in there once.
Okay.
So
But you didn't speak to anybody else besides Miss James, is that correct? Like direct?
I directly interviewed Miss James. I was present while other people were speaking inside the residence, but I did not directly say, I'm going to interview you for a police report.
Do you know if any of the other three officers on scene did?
I can't speak for them.
Okay. But you didn't see them?
Did you see them interview?
Yeah.
They were inside the house. They very well could have interviewed these other people.
So you don't know?
I could not give you a no.
Yeah, okay. And you said you leave the property, that you take some photos and other investigatory scenes, is that correct?
I took some photos. I interviewed the witness. I got her loaded up with LFP. I collected evidence. And that was the extent of.
Did you interview her at the hospital as well?
I did go back to the hospital and asked her to describe the weapon.
Okay. And since you met with Miss James at the hospital back in August of this year, did you do anything else on this case besides testifying to that?
No. Not that I recall anything else.
And you had mentioned that you'd been out to this home that night. You've been out to this home before that night.
Not that I recall, not that home. We go to that area a lot, but not to that specific residence that I recall.
So Miss James and the other members of the people present at home, you've never met them before that night.
Yeah, I believe that.
You're right, no additional questions from the officer.
Just procedurally speaking, Officer Fox, were you the one who took official statements from these other people inside the house? If official statements were taken from those people, would you expect another officer to have submitted a report for that?
If another officer took official statements from them, they would have submitted a report.
So just because these people were talking near you doesn't mean you have to put it in your report.
Correct.
Thank you. I have no further questions for this witness.
Thank you, Officer Fox, maybe excuse.
Yes, Your Honor, the people would call Officer Nicholas Rincon to the stand. I did get an email from him at 12:28 saying he was 15 minutes out, so I think he should be here. Let me just go check.
Very cool.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
You can have a seat. State your first and last name and spell both.
Nicholas Rincon, that's Nikolas, and last name is Rincon.
Thank you. See, counsel.
Yes, Your Honor, thank you. Officer Rincon, thank you for being here with us. Are you currently employed?
Yes,
Where?
the city of Lansing.
How long have you been employed there?
I've been with Lansing for a little over a year.
What's your current rank and assignment?
I am a patrol officer, and I work the road.
I'm going to take you back to the date of August 10th, 2024. Were you employed in that same capacity on that date?
I was.
On that date, around 5 a.m., did you respond to a call involving a assault, a possible domestic situation?
Correct.
Where were you in order of response? Were you the first responder?
Myself and another partner of mine were the first initial response.
So let's talk about the initial response. Did you approach apartment 6 located at 1904 Georgetown Boulevard?
Correct.
Upon your approach, could you hear or see anything from the outside of the door?
I think I heard some chatter, some sort of talking and like some loud noises. So we didn't have an address at first, so that kind of led us to that door to knock on it, and it was eventually answered.
And would you describe it as just chatter or something else? You said
So
that
quite the commotion. It was a lot louder than just normal chatter for 5 a.m. But
so you approach this door, you hear people making loud noise inside.
correct.
What do you do?
We knock on the door, someone answers, and we're immediately met by a female who's in distress, essentially.
What do you mean in distress?
She's waving us in, panicking, kind of, you can see that she's upset and she's trying to get us to come into the apartment quickly.
Who was this? Did she have any visible injuries?
So there was like 3 people that came to the door. There was 2 at the door, and then there was someone behind them. One of the females that were kind of in the doorway from my initial view did have injuries. I could see blood on her face and kind of on her hands.
Now this other individual that directed you to someone in the house, who was she? Do you know?
So I know there was an elderly woman, I believe that was grandma. She was kind of yelling and pointing towards the back hallway because we're trying to figure out what's going on. It's quite a commotion when we first entered.
Were you able to determine what was going on?
Yep. So someone yelled out. I don't know which female did. He stabbed her. And as I looked to the direction they pointed, a black male came out of the back hallways, kind of with his hands up, as if he was like surrendering to us.
What did you do at this point based on the information that you kind of got greeted with at the door?
Yeah, so based off of that information alone, with seeing the visible injury and blood and possibly there being a knife, I immediately tell the male to put his hands behind his back because I'm going to detain him for that time being until we can make the scene safe and continue our investigation.
What did he do at this time?
As soon as I grabbed his arm, he yanked it away from me and ran towards the back hallway and went into a bedroom and locked the door.
What did you do?
Immediately chased him with my partner. We tried to get into the room. My partner eventually kicked through the door, and we observed that he had jumped through the bedroom window and shattered it. So we left the apartment and continued on foot after him.
Long story short here, were you able to catch up with this suspect?
Yes. Yep.
Who's your partner? You described your partner.
Jonathan Bynum.
Okay. When you and Officer Bynum arrived at the scene, what were you wearing?
We were in full uniform, badge, gun.
Would it be obvious to those around you that you're a police officer?
Absolutely.
Okay. Including this person who ran in behind a locked door?
Yep.
Okay. Were you at any point giving him lawful commands prior to him making these actions?
I told him to put his hands behind his back, and I told him to stop when he was running from me.
Did you continue to give him lawful commands?
After we went through the bedroom window, my partner was ahead of me, so he was taking control of command. So I was kind of further back, so I wasn't screaming over the top of him.
So fair to say that your kind of part of it was telling him to put his hands behind his back and then he flees into that locker.
Absolutely. Yep. He ripped from my grasp.
After he gets out that window, your partner's ahead of you. Is that
Yep.
fair?
Yep.
Could you hear your partner yelling at him, telling him to stop, anything like that?
Yeah, I could hear him screaming police and putting stuff over the radio so our partners could know where we were headed.
At some point after you caught up with this individual, did you search his person?
Yes. Yep. After we secured him in handcuffs, we took him back to our patrol vehicle and searched him.
What, if anything, did you find on his person while searching?
I located a cell phone in his pocket.
Was it his cell phone?
No, it was the grandmother.
How do you know that?
She confirmed it and I had her confirm it by putting the passcode in her phone.
I'm going to approach you with a photograph here on People's Exhibit number 2. It's already been admitted into evidence. Do you recognize that photograph?
I do. I took that photograph.
What do we see on that photograph there?
At 5:19 a.m., somebody called emergency services. And then again at 5:25 a.m., they also called emergency services.
Do you have any information based on your investigation to determine whether or not these calls were successfully completed, whether they were prevented, whether they went through?
I did not interview grandmother directly, but from overhearing when my partners were giving the interview with them while I was still photographing and processing the scene, it sounds like the phone was taken away from her by the accused, so she could not call 911. And finding the cell phone in his possession would kind of go along with those statements.
Thank you, Your Honor. I have no further questions for this witness.
Thank you. Morning, officer.
Good morning.
Excuse me. So you've been with the Lansing Police Department for 1 year, is that correct?
Yep, just a little over a year.
Were you with another agency before that?
Correct. I worked for the Jackson Police Department, the city of Jackson.
How long were you with Jackson?
I was there for a year and a half.
So you've been an officer for 2.5 years?
Yep, just shy of 3.
Okay. And I presume before you went to Jackson, you went to the police academy, is that correct?
I did. I went to Mid-Michigan Police Academy.
You were trained at Mid-Michigan to make an accurate and complete police report, is that correct?
Correct.
And you probably were trained by not only Jackson, but Lansing to do that as well, is that correct?
Yes.
Okay. And you did make a police report in this case, is that correct?
I did.
And to your knowledge and belief it was accurate and complete?
Correct.
Okay. So let's talk a little bit about, so you were one of the first officers you were the first officer to arrive, is that correct?
Me and my partner arrived at the same time.
Officer Bynum, is that correct?
Yep.
You go into the house and if I understand your testimony correct, he ran through the window. Did you arrest him in the house or was he outside the house? When you arrested
He was outside the house when we arrested him.
Did he self-surrender or what happened?
He essentially got tired and laid on the ground until we took him in
But
custody.
nobody tackled him, nobody.
Nope, we did not have to tackle him, no.
Okay, and you said, did any other officers arrive after you got there to help with the chase?
Yes.
What other officers arrived?
I believe Mark Fox arrived on scene and another officer also arrived on scene.
You're not sure his name?
No.
Okay. And you said that, what did you do after you took the person you found out there into custody? What did you do after that?
We walked him back to our patrol vehicle and we searched him.
And you said that you found the phone out, is that correct?
Correct.
Let me ask you this, you said you made a police report of your incident, is that correct?
Yes.
In the police report, did you mention finding anything on the person you found?
I documented the photographs that I had taken.
Did you mention anything about finding a phone on his possession?
I do not recall.
If I showed you your report, would that help?
That would.
Yeah, Georgia.
Yes.
We should look at this report and then you're finished. Back to experience.
I do not see anything regarding that.
And why was that out of the report?
I do not know.
Okay, and you believe that would be important information to know, is that correct?
Yeah, it's something that could be documented, absolutely.
So you really, and you said when you found the phone, you found the emergency calls, but you can't say for certain when you took the phone from her, is that correct? You didn't take the statements.
No, my partners did the interviews with those subjects.
And have you seen any of the individuals that were on the scene, both either the person in custody or the people in the home before that?
Have I seen them?
Yeah, you interacted, have you been called on a service call to that house before?
Never, I have not.
So those people
Personally.
were all people you've never met before?
Correct, yep, all new faces from it.
And after you secured the person in custody, you went back to resident, what'd you do after that? Anything else before today?
Sorry, can you?
I'll rephrase the question. Did you do anything after August 10th on this case besides coming to court? I mean, did you do any further investigation to?
No, for pertaining this case, no, I'm not.
Okay. I have no further questions for Officer Rico.
All right, any redirect.
Yes, Your Honor, briefly. Procedurally speaking, Officer McCullum, how do we get photographs that you take at a crime scene?
I upload them either directly or to the report through Axon Evidence.
Is there any sort of thing that identifies who uploads these? Is your name on it when you upload it?
Absolutely. So my name is connected to the account, and when I upload something, my command and department and anyone who has access to Axon can see who uploaded that photo, what time,
Is there any
and their
relevance to
location.
this, Your Honor?
Listen, I went.
Sounds like there was a question to the authenticity of the exhibit. That would be the reason I'm laying the foundation for it, of who took it, how it was taken.
My question was about why it wasn't that report, nothing to do whether it found it or not, or how we knew whether the content emergency room was taken.
I can rephrase.
Okay, thank you.
Just because something is not in your report, does that mean you didn't do it?
No.
Would we, of course, strive for everything to get into your report?
Yeah, absolutely.
Are things sometimes left out?
Yeah, human errors, absolutely.
Did you take that photograph in exhibit 2?
I did take that photograph.
Did you find the phone on his person?
I did.
Did you have information to determine whose phone that was?
Yes.
What was that?
That it was the grandmother's cell phone.
Is there any particular reason that Mr. McCollum gave or volunteered as to why he had someone else's phone in his pocket?
I believe he did not provide a statement for us, so.
Fair enough. All right. But no further questions for this witness. Thank you.
Thank you, Officer McCullum, you need to. Call your next witness.
No further witnesses, Your Honor. People rest.
None for purposes of preliminary exam, Your Honor. Thank you.
Argument.
Could I approach to retrieve the exhibit, Your Honor?
Yes, yeah.
May I proceed, Your Honor?
Yes.
Your Honor, as you are well aware, we're here for a preliminary examination. This is a probable cause standard, probable cause to prove that a felony was committed, probable cause that this defendant is the one who did it. I will start with, there is no real, at least that I saw brought up today or that exist on my review of the case, any real stops, searches, seizures, traffic stops, anything like that to address. So I want to kind of argue this in the context of what we have here is really a sufficiency of evidence hearing, whether or not there is enough evidence to bind this defendant over on the 2 cases and the several counts that are in. I will start with file number 2303167FY, the home invasion case, because I am not seeking to add any additional charges on that file. Regarding the preliminary matters, Your Honor, we had location, offense, venue, date, ID, all done on the record today by Shanetta Beasley. We identified the location of 1412 Georgetown Boulevard, Apartment 6, City of Lansing, Ingham County, State of Michigan. The date of May 24th, 2023. She also identified Quandell McCullum, someone that her daughter had a romantic relationship with and she knew very well. Here in court today. Regarding the elements I have to prove under home invasion first degree, charging under a breaking and entering theory, I'm looking at Michigan Criminal Jury Instruction 25.2A. I have to prove first that the defendant broke into a dwelling, second, the defendant entered it, and third, that when he broke and entered in the dwelling, as charged, he intended to commit an assault therein. Your Honor has the photograph of the broken window, of the damage. One of the examples would be breaking a window listed in the jury instructions, or even simply opening a door, raising a window. We've established breaking. Shanetta Beasley testified that after hearing glass shatter, which woke her up, she approximately 15 to 30 seconds later made her way over to this bedroom where she turned on the hall light, positively identified the defendant, and noticed that his body was halfway in, halfway out of the building at this point. At that point, he's entered. As is in the jury instruction, it does not matter if he got in his entire body inside the house or not. When he entered the dwelling, he intended to commit assault therein. Not only did he intend to, Your Honor, as could circumstantially be proven by showing up to someone's house at 5 a.m. in the middle of the night and breaking through their window, but he actually committed an assault. He put his hands on Tamaris James. He pulled her, he yanked her, as was described by Shanetta Beasley. So his intent is clear. By Michigan Criminal Jury Instruction 25.2A and the elements that we're bound to prove here today, we have proven home invasion first degree. It's a habitual fourth offense notice that will automatically transfer, already making you face the potential possibility of life. I would ask Your Honor to simply bind that case over as charged. Where Shanetta Beasley's testimony comes really important today is with the other five. 2402346FY. While she wasn't involved in this incident, this several count of great bodily harm, she did see her daughter after. She's seen the medical treatment she had to get. Her daughter has described to her that she was stabbed in the legs, the lip, bruising all over, a big gash to her right eye, and then through other witnesses, we admitted a photograph that corroborates exactly her statements. She described permanent damage done to Tamaris James. She described that she was in the hospital for at least 1 day and then has been seeking medical treatment since for these injuries. I know it's a little out of order and unusual for me to do things this way, Your Honor, but I also know I'm asking for a lot here. I did plenty of research on the case law last night for assault with intent to murder. I specifically searched cases involving a knife for factual comparison. I also specifically looked into any sort of sufficiency of evidence tests and how successful they've been on appeal. I found several pieces of case law that I could reference you to, Your Honor. I'm not going to bore you with all of them. People versus Erickson, ERICKSEN, 288 Mich. App 192. It's a 2010 case. It is the most recently published case I could find in Michigan involving sufficiency of evidence with assault with intent to murder and a knife being used. This particular incident, the defendant stabbed the victim 5 times after the victim had an altercation with a member of his family. Why I think this case is important to Your Honor's decision is because looking at pages 196 and 197 of them, the appellate court specifically noted that medical evidence showed Rick Taylor's right back had 4 knife wounds. We don't have medical records like they had in that case, but we do have Shanetta Beasley's testimony of what her daughter has advised of her and the photographs there that would suggest she had to get medical treatment. What the court said in that is that the defendant's intent could be inferred from any facts and evidence, including the nature, the extent, and the location of these wounds. The court held that it has consistently observed that because the difficulty of proving an actor's state of mind, minimal circumstantial evidence is sufficient. That's a quote from People versus McReynolds, 237, Mishap, 168. Defendant in that case challenged sufficiency of evidence as to his state of mind and whether or not they could prove he intended to murder the victim, and the appellate court told him, no, the evidence was sufficient. People versus Hodges, 179, Mishap, 629, 1989. I bring this case up because I find it factually similar. In this case, a complainant was kidnapped, put in a car, threatened to kill, had a knife held to her throat several times before it was ever used, and then when she started to scream for help, the defendant started to slice her. And the only reason that this assault was stopped in this case was because a police officer was able to observe the struggle, approached, and broke it up. That's a lot like our case here. In People versus Hodges, the defendant made some arguments on appeal that because the victim was not dead, it was indicative that he didn't intend to kill her. The court found otherwise and held in favor of the state in that case, finding that police officers breaking the event up did matter. Finally, one case that I think is incredibly factual similar to this pattern, Your Honor. People versus Fernandez, 143, Mishap, 388, 1985. For the record, this case has made its way to the Supreme Court. It was appealed, but it was not appealed on any of the grounds that I'm going to talk about. It was just sentencing appeals. It had nothing to do with the factual basis of the decision the court made. In this case, the defendant and the victim were married. The victim told the defendant she wanted a divorce over the phone, at which point the defendant began to threaten. Said he didn't know what he would do if he saw her with another man. Then almost a year later, they have another conversation. The defendant is now more deliberate in his threat, specifically asked the victim if she still works in the morning and tells her that he will either go to jail for killing her or he'll get someone else to do it. Fernandez, this particular defendant, was charged with conspiracy crimes. He was not actually the perpetrator. Instead, what happened to the victim was that she was shot at one day by a man in a military jacket while driving to work. And then she left her house the next morning to have two men in military jackets approach her. She screamed. They came at her with a knife and stabbed her exactly one time. One stab. She ended up in hospital for it. She spent a few weeks and had a surgery over it. She had permanent damage. The court in that case indicated that the medical evidence, that the wound, and that the time she spent in the hospital was indicative of the intent on top of the weapons used. But more importantly, Your Honor, those two men who actually perpetrated the crime in that case pled guilty to assault with intent to murder for those facts, stabbing someone one time who ended up living. Your Honor, there are several other cases where knives are not even used, where there's not even a weapon used, where, for example, gasoline was simply poured in a building and no flame was ever lit, and assault with intent to murder has been upheld after jury trials on appeal for a sufficiency of evidence challenge. I've laid out the law now, and I think you know where I'm going with this. I am seeking to add assault with intent to murder pursuant to Michigan Criminal Jury Instruction 17.3. Procedurally speaking, I think the best way to add this charge would be as a count one. It is the most severe. It is the possibility of life by itself. In the alternative to count one, I would be requesting this court to bind over those two counts of assault with intent to do great bodily harm that are already charged. So what I'm asking is to bind it over as a new count one for assault with intent to murder, and umbrella those two underneath, or if Your Honor feels it's more appropriate to do the GBH as a count 2 and 3 upon bind over, I would be fine with that too. Regarding assault with intent to murder, Michigan Criminal Jury Instruction 17.3 states that the defendant, 1, tried to physically injure another person, 2, that when he committed the assault, he had the ability to cause an injury, or at least believed he had the ability. 3, that the defendant intended to kill the person he assaulted. Your Honor, what we have in this case is pretty similar to that Fernandez case I mentioned. Almost a year after breaking, or a little over a year after breaking into Tamaris James' bedroom to assault her, this defendant shows up and assaults her again. Whether or not they've had a relationship continuing on at that point is frankly irrelevant. What we have is a little over a year later, this man then commits this assault. I think continuing to assault her in the way he did is indicative of intent. On top of that, he assaults her starting outside, as we heard testimony from Officer Fox through what Tamaris James was able to report. The assault starts outside the house. In the yard, he jumps on her. Then she's able to get him to calm down, take him to bed to get him to calm down. Then he gets mad again. Then the assault continues and he slaps her, and finally, Tamaris fights back. She slaps him back. At this point, the defendant, I would argue, is enraged. He knows what he's doing, and he knows what his intent is going to be after this victim of domestic violence finally fought back. He picks her up after beating on her on the bed. He has her transition from a fight that was described as starting on the bed to standing. He continues to pound on her head. He then, as we see in all of the photographs here, assaults her so bad that there is blood throughout the house, blood on her grandmother's porta chair because he was hitting her in. Blood on the floor because of her wounds. Blood on the dresser because he was hitting her head in. And then, after doing all that, he decides it's not enough. So he goes to a separate room, gets a kitchen knife, a 6-inch blade, serrated kitchen knife, comes back, and he does this to her. Not just this, but also stabs her in the thigh, stabs her in the torso, leaves bruises all over her, slaps her with the knife, and then creates that gash to her eye that she is now going to have to live with for the rest of her life because of this man. On top of all that, someone finally gets smart enough to want to call police. And then what did we hear happen? We heard that the defendant took someone's phone, a phone that was then found in his pocket with 2 attempts to call an emergency number screenshotted right there. That supports the interference charge by itself. Assault with intent to murder is indicative of this whole situation. Regarding strangulation or suffocation, as is currently charging count 1, but I would be asked to do an alternative count 1. We heard from Officer Fox that the victim described he grabbed her by her esophagus. I understand we didn't have great testimony about difficulty breathing, loss of consciousness, or any of that, but I would suggest to you, Your Honor, circumstantially by indicating where she was grabbed, how she was held down, and how long this assault lasted, a period of approximately 10 to 15 minutes, I would argue, Your Honor, you have more than enough for probable cause for at least 1 count of assault with intent to do great bodily harm by strangulation or suffocation. The second charge in this for great bodily harm is simply normal great bodily harm. Michigan Criminal Jury Instruction 17.7. We've established that throughout the course of this assault, pounding her head against the ground, using a knife on her, all of these things indicate 1 assault with intent to do great bodily harm in an alternative. We have currently charged count 3 with the resisting and obstructing of Officer Nico Rapone. I considered adding more, but I won't ask for that, Your Honor, given the fact that the evidence didn't support Officer Bynum tackled the defendant. As for the Officer Rincon charge, he was performing his lawful duties. He testified he was in uniform. This defendant would have been able to see it. He was giving lawful commands to stop, and then this defendant went into a room, barricaded himself to the point where the door had to be kicked in. He then fled out the window until he finally just gave up because he got tired. We've met the elements for that. Interference, I've already gone over. What I will be requesting to add on top of the assault with intent to murder, Your Honor, is a charge of felonious assault as an added count 6. For that, Your Honor, I am looking at Michigan Criminal Jury Instruction 17.9, Your Honor, assault with a dangerous weapon. First, I have to prove that the defendant either attempted to commit a battery on Tamarius James or he did an act that would cause a reasonable person to apprehend an immediate battery. You have the photos, you've heard the testimony, you heard what he did with the knife. We've proven that. The defendant, second, that the defendant either intended to injure the complainant or to make the complainant reasonably fear an immediate battery. Not only did he intend to do it, he did it, and it's permanent. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought he had the ability. Not only had he beat on her the way he did, but he brought a knife to the fight. He had the ability. Fourth, that the defendant committed the assault with a dangerous weapon. A 6-inch serrated kitchen knife is a dangerous weapon, and that's shown in People's Exhibits 3 and 4 with the damage it did to Tamarius James' face from one single swing. With that, Your Honor, I think I've said more than enough. In summary, I'm asking for bind over on case file 2402346FY as an added count 1 for assault with intent to murder. In the alternative, the 2 counts of GBH that are already charged, count 3 being resisting and obstructing, telephone interference being count 4, and an added, I guess we're at a count 5 now for felonious assault. Or I apologize, I missed the aggravated domestic violence charge that was on there. It's already at count 4. 5 is interfering with electronic communications. 6, I would be adding for felonious assault. The aggravated domestic violence is technically a misdemeanor, Your Honor, so I didn't need to put in personal. Thank
You gave a number of citations, and I think that I would need to review some of those cases, some of that case law, actually.
Yes, Your Honor.
Before rendering my ruling. I don't know if you were previously made aware that he was intended to.
I was, but I did not get any of the case law.
Okay, so we'll, you're free to give your,
But I have no way to review the case law. I have no.
I was saying you're free to give your argument now, or you can hold it, because I'm going to make sure we have all the accurate citations. I tried to jot them down as he was going, give you opportunity to review the case law. The court needs to do the case law as well. And then we'll come back for the ruling at another date.
I just prefer that. Let's make an argument.
You want to do your argument now, or you want to wait until you have an opportunity to review the case law?
Case law.
Okay, so
Before
we'll
we
do,
come back another argument, I might just, the court's inclined to do that.
I'm going to do that regardless, because I want to review the case law.
I'll make the argument.
Okay.
I think that's probably better.
Let me just get a next available date. I don't need that much time, I just need the citation. Even if we have to squeeze it in, are you available next week?
I'm here. What, Monday?
No, the 20th, I think.
Today's Friday.
Friday?
Yeah, I'm here. Yeah.
Friday. We can squeeze it in Friday.
Oh, yeah, I know I wouldn't be available this Thursday afternoon, but I can make Friday.
Okay, December 20th at 9 for ruling.
Is that at 9 around?
Yeah, you'll give your our argument, there'll be re-argument and then a ruling at that time. Any additional matters for today's record?
For the people, would you like me to just email
That would be better
Your
if you
Honor with
email us
Mr.
both.
Fido since
Yes.
CC'd and all the citations on it?
That'd be perfect. Thank you.
So, Judge, I'd like to address one thing, in regards to the bond. I know back in October, Mr. McCullum had his phone privileges restricted. I know there was issues with him having alleged contact or admitted contact with regards to Miss James, Your Honor. He has expressed a desire for me to be able to have contact with his family. He does wish to not have any contact with Miss James. I think we could potentially block her number from him getting calls. I would ask him to allow to have phone privileges in the state.
I may, Your Honor.
You may.
I'll ultimately leave it up to Your Honor's discretion. I think you're more than competent to make that decision. I would just like as a factual reminder, because I was looking at myself last night, this is the same defendant after having his privileges revoked, found 3 or 4 other inmate calls to use and had the victim create a separate number and a separate account, not under her name, to try to avoid all this detection. So I'll leave it up to your discretion. Ultimately, Your Honor, I just wanted that on there.
I'm reviewing my notes from August 22nd, 2024. I think the allegations were there had been. The defendant called the victim allegedly 187 times from the jail and used other inmates' numbers. An additional amount of times that increased the calls to 227 calls, plus calls from family to 3-way call her. So you're now asking for him to have permission so he can call his family.
Correct, I don't know if they ever submitted proof that he had used his family to call Miss James or.
I don't know what they had either, but
But guilty to the violence.
that's why I know proof would have
But
been.
that was for contact to her, not with regards to contact.
Included in that report for the PA 53 violation was those allegations you're talking about.
I think what he's saying is that when he made an admission, he admitted to contacting her. But he never made any admissions with regards to using his family.
Okay, that was the allegation. That there were several phone call, video calls to victim while in Ingham County Jail. And the allegation specifically stated on the record was that there were 3-way calls to family to her. And I recognize no evidence or information has been turned over, but we obviously know that this is information is easily verifiable. And there more, before these allegations could even be brought, someone probably looked into it. And the amount of calls, I think these are numbers that are made up. We're talking about 187 calls and then additional calls for 227. That's a blatant disregard for court order and blatant disregard for the fact that they're telling you this is a recorded phone call. And then I don't know if the prosecution ever had a contact with the alleged victim prior to this, but we had their obviously perceived victims at this point. And who knows if it has anything to do with these, this contact that was made. Again, there was allegations of messages being supposedly sent to her. I think there was a description of the message in one of the reports. The court's not comfortable with reinstating those privileges. Because when the court advised Mr. McCullum of the restrictions from the beginning, he completely disregarded it. So he took his own privileges away. The court didn't do it. I didn't have a choice. I'm assuming that there's not going to be any witness interference charges brought forth. That
There is a case pending in review that was originally included in the offer we discussed that was proposed yesterday. He declined that offer, so now we're going to proceed on that file as well.
there's potential. witness
Well,
interference charges.
assuming it gets screened and authorized, I guess I can't.
As I said,
Sure,
potential,
haven't-
there's
I haven't-
potential witness interference charges.
So that was made a part of the offer that was conveyed along with the adding of the solvency for charge.
The motion is denied. Any additional matters for the record?
Nothing to people, thank you.
Nothing on behalf of this call, the CIC.
Email the citations of the table.
Thank you so much.
Well.